quorum is present. We'll stand and Commissioner Walden will lead us to the pledge of the flag.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
We have a long agenda this morning, and I hope to move through it as rapidly as we can, but we want to give everyone an opportunity, both on and off the commission, to speak. I do have some preliminary announcements. As you know, we are guests here in the First District Court of Appeals, so we have to abide by their rules and regulations, and one of those is that nothing but water in terms of food or beverage is allowed here in the courtroom. Everyone, please silence your cell phones. Anyone addressing the commission, everything is recorded, so please speak up into the microphone so that what you have to say can be properly heard by those present and also properly recorded. Pursuant to Section 286-0114 of the Florida statutes, members of the public have an opportunity to input on matters before the commission at the appropriate and proper times in which we are acting in a quasi-judicial capacity. This means that the public can have input on matters other than complaints, opinions, and determination in financial disclosure cases. If you desire to be heard on a matter, please fill out a speaker card and give it to Mrs. Fulford, who is in the rear of the courtroom. The next item on the agenda is the approval of minutes. They have been circulated to all of the members of the commission. We've had an opportunity to read them. Are there any additions, corrections, or a motion for acceptance?
So moved.
Which one?
Acceptance.
Second?
Second.
All in favor say aye.
Aye.
Opposed, like sign. The next item is consideration of final action on recommended orders. We have two of them. The first one is Carlos Beruf. It is a recommended order of the administrative law judge for the Division of Administrative Hearings in complaint number 20-186. It recommends that the commission find the respondent violated section 1112-3145 of the Florida statutes, and for that violation, recommend public censure and a reprimand and a civil penalty of $1,500.
Mr. Chairman?
Yes.
Mr. Chairman, I'd like to make a disclosure, if I may, sir.
Yes.
Mr. Beruf and I served together on the Constitutional Revision Commission. I don't believe that will affect my judgment in this matter, but I wish to make the disclosure.
Thank you, so noted. The respondent has filed timely written exceptions to the recommended order, and thereafter the advocate filed a response to the respondent's exceptions. The full record is before you. We have a full draft order recommended by our staff that analyzes the rules on each exception and adopts the recommendation of the administrative law judge. The draft order was provided to members of the commission, and a supplemental mail out and the staff's hard copies are available if you need one. The respondent and the advocate will be given 15 minutes each for argument. The respondent will argue his exceptions and the advocate will argue her response. Commission members, staff, and others may comment accordingly. And the commission can decide if we want to reject or modify a conclusion of law, but it has to be done in a reasonable manner. With respect to the total penalty recommended by the administrative law judge, the commission may, upon review of the full record, reduce or increase the recommended penalty, stating particularity and the agency's reasons for increase or reduction. Will the parties or their counsel please identify themselves for the record?
Mark Heron on
on behalf of Carlos Baruf.
So noted. Is there any discussion by members or any motion?
Mr. Chair, I think I have my 15 minutes before you coming up,
I apologize.
before you get any motions.
All right, you're recognized, Ms. Taryn, for hopefully not 15 minutes, but
Mr. Chairman, members of the commission, my name's Mark Herron, and I am representing Carlos Baruf here before you. We filed 5 exceptions to the recommended order, and if I don't get to all of those 5 exceptions in my presentation, I don't intend to waive anything that we've put forth in our exceptions. The first exception, and again, they're addressed in our filing of exceptions, and the staff's draft is the rule challenge. And the language with respect to the rule challenge exception is on pages 7 through 11 of our exceptions. Our exception here is based on the language of the statute itself. Section 112.31453 specifies the respondent was required to either disclose the location or descriptions of the properties on his Form 1 filing. The statute on its face does not specify the level of detail necessary to comply with this requirement. The statute facially allows disclosure by location or description. The Commission has utilized its rules-making power to interpret Section 112.31455 and its disclosure requirements by adopting Form 1 disclosure. And the requirement is that in the rule that you have to set forth your disclosures if a street address is required. It's our position that the Commission exceeded its rulemaking authority when its actions amount to an invalid exercise of delegated authority. And the statute defines what that is. And it includes the rule enlarges, modifies, contravenes the specific provisions of law implemented by the rule. Neither Section 112.31453A3 nor 112.31453B3 require a respondent to identify real property by using a street address. No other provision of Chapter 112 with respect to Form 1 requires the listing of properties by a street address. There is no question the Commission mandates Form 1 filers to list real properties by street address if one exists. By mandating a street address it must be used, the Commission exceeds its rulemaking authority. There's a statute, 11257(1)L, which provides that the Commission may not take any action based upon a requirement in the Form 1 instructions that a street address be used if one exists. That's the essence of our challenge. The ALJ rejected that, but we believe that that rejection was improper, and we'd ask you to grant our Form 1 exception. Our second exception, and I'm going to get my glasses, because the reason I'm a little choppy here right now is because I don't have my glasses on. Give me a second. It's tough getting older because I never used to have to wear glasses to read, and now I do, and it drives me crazy. Exception number 2 is our argument that Form 1 does not unambiguously require the disclosure of property addresses. By its plain terms, the instructions specify that the location or description of the property should be sufficient to enable anyone who looks at the form to identify the property. A street address, again from the words of the instructions, should be used if one exists. It's our position that the instructions do not mandate the manner of describing property location by street address. Should is a hortatory form of word, meaning to urge or to encourage, not to mandate. And this language, my citation of that is from a Florida Supreme Court in the Code of Judicial Conduct, where they say that should is not necessarily a mandate. To be clear, if the commission intended such details, it would have had specified that such information is required, or the filer must list such information by street address. The commission knows how to specify, and the legislature knows how to specify when a particular form must be used. For example, in Part B provides that a filer must list every source of income. In Part F, a filer must list for businesses for which the filer served as an officer or a director. So the commission knows how to use the word must and should know the difference between must and should. Our third exception is that there's no competent or substantial evidence that respondent could list property by street address. This exception can be viewed in this way very simply. The forms were filled out in 2014, 2015, and 2016, whatever the dates were. The advocate and the ALJ premised that the addresses existed because Mr. Baroof filed Form 1X amendments in 2019. But there's no evidence in the record that those addresses existed at the time the forms were filed. So we suggest that this finding should be rejected. Exception number 4. There's no competent or substantial evidence which proves the respondent omitted properties in his Form 1 filings. The recommended order erroneously finds that respondent's Form 1X amendment disclosed numerous additional properties, thereby implying the original Form 1 filings failed to disclose certain properties. The administrative law judge so concluded because the respondent's Form 1X amendments included additional line items in his property disclosures. But respondent's original Form 1 disclosures, in many instances, describe properties in bulk. For example, listing multiple lots in the inlets at Bradenton, Florida. Again, when you shift to listing by street address, you're going to have more line items. And so that's where the administrative law judge, I think, jumped the rails here. There's no evidence that the properties more specifically identified on respondent's Form 1 amendments were not included in the general descriptions of location and descriptions that he complied with the statute. Exception number 5, we suggest that the penalty should be reduced or eliminated because the ALJ's recommendation of a penalty was largely predicated on her erroneous legal conclusion that respondent had to list reportable real property by street address. If in fact we are correct that he did not have to list each property owned by street address, then respondent's only errors were his failure to check the box indicating on how he reported his interest. Do you do it by the comparative message or the threshold method? And his omission of several businesses in which he himself owns that it were either primary or secondary sources of income. There was no evidence that respondent voted on any matter in which he had a voting conflict under the Section 112-4143, and the unrefuted evidence proved that any omission by the respondent was innocent, immaterial, and did not negatively affect his private interests. A significant fact in this entire investigation from beginning to end was there was another portion of the complaint that the commission early on found no probable cause, and that was a voting conflict. And the voting conflict was identified and investigated based on one of these bulk descriptions of him owning property, I believe, in the inlets in Bradenton. And it was determined after that long investigation that they were able to investigate based on that. And the purpose of these disclosures is to identify conflicts. And so the conflicts that were on the Form 1, or the identification on the Form 1s, were sufficient to trigger an investigation of a potential conflict and to make a determination that was none. So it's our position that the fine of $1,500 is excessive because of the nature of what occurred in this case and the nature of Mr. Barouf's history of filing Form 1 disclosures, which he filed them for a number of years. No one at any point identified any problem, and he continued that until this complaint was filed. Once the complaint was filed, he engaged counsel. Counsel advised him that we need to follow the rules of the commission, notwithstanding our position that the rules exceeded the commission's authority, and he filed the amended Form X's, and he continues to do so today. So we suggest that this case ought to be treated as a de minimis case, and in determining whether a violation was de minimis, the commission shall consider whether the interests of the public were protected despite the violation. We suggest they were. And the evidence adduced at hearing demonstrates the de minimis nature. For all these reasons stated above, any penalty imposed against respondent should be eliminated or reduced to fit the applicable circumstances. I see I have about 4 minutes left, and if possible, I would reserve some time.
Thank you, Mr. Herring.
Thank you.
Ms. Hadley? You recognized?
In this case, Mr. Barouf violated Section 112.3145 Florida statutes. Clear and convincing evidence proved that he failed to accurately disclose his interest on his 2013, 2014, and 2015 financial disclosure forms. Respondent's primary theory regarding the rule challenge is that the commission filed or implemented an invalid rule, and that's based on Section 112.31545 Florida statutes, requiring that the location and description of real property, and it says that the commission, he's argued that the commission exceeded its delegation of legislative authority by asking for an address if one is available. Respondent's theory is wrong, because the language of a rule need not be identical to the law implemented to be valid. If such were the case, there'll be no need for rulemaking. Agencies are permitted and even required to interpret the rules they implement. Use of the term interpret suggests that a rule will be more detailed than the applicable enabling statute. The interpretation must also be consistent with the purpose of the law implemented. When a term in a statute is not defined, the rules of statutory construction allows courts to interpret the rule according to its ordinary meaning. The term location or description of real property is not defined, therefore the ordinary meaning of the term must be relied on. The ordinary meaning of location or description of property includes the address of the property. This interpretation is also consistent with the purpose of the law implemented, which is to enable the public to locate the property listed on CE Form 1. The text of Section 112.3145B3 Florida statutes is clear that if reportable property is owned, the legislature wants its location identified. In asking for the address, CE Form 1 employs an ordinary meaning for location or description that is consistent with the purpose of the statute and does not enlarge, modify, or contravene the law implemented. Nowhere within the recommended order does it say that respondent violated Section 112.3145 Florida statutes by failing to list the street address for his vast number of properties. In actuality, the administrative law judge found that respondent, one, failed to properly disclose those real property interests by any means on his 2013, 2014, and 2015 forms. Two, that he failed to indicate whether he used comparative or dollar value thresholds as his method of calculating reportable interest on his 2013 and 2014 forms. Three, that he failed to list one or more primary sources of income on his 2013 and 2014 forms. And four, failed to disclose secondary sources of income on his 2013 and 2014 forms. In this case, the ALJ found that respondent did not provide the location or description by any of the means available to him, for example, a legal description. The ALJ described the alternative means by which the filer could disclose real property interests, not only street addresses, in Conclusion of Law 88, and how respondent failed to do so in Conclusion of Law 87. For instance, respondent's 2013 Form 1 had approximately 35 listings of disclosable properties. Now, with that review of those 35 listings, it doesn't provide an accurate disclosure. It says multiple lots. In comparison, on his 2013 Form 1, he had over 740 listings of disclosable properties. On his 2014 form, he told us that he had over 640 properties to disclose. On his 2015 form, amended form, the same. After these failures to disclose, the respondent received the benefit of the doubt from the ALJ, who recommended a $1,500 penalty, but yet asked this body to reduce the penalty even further. I argue that every inaccuracy on respondent's financial disclosure form is relevant to the public. For instance, every response on his form is dictated by which box he checked on his manner for calculating his reportable interest. Whether respondent intended to file an inaccurate form is irrelevant. Intent is not an element to prove a violation of Section 112.3145. In addition, respondent argues that there was no evidence that anyone was misled by his inaccurate forms. First, whether anyone was misled is not an element to prove a violation of Section 112.3145. And as it was not an element, it was unnecessary to provide evidence at the hearing. The ALJ specifically rejected the argument regarding that the failure to disclose the manner of, the failure to disclose the manner of calculating one's reportable interest as being de minimis. That was in paragraph 76. The imposition of a penalty is important to deter future ethical misconduct and critical to ensure the public's trust and confidence in our system. I've been serving as an advocate since 2009. This is by far the worst case of failing to disclose that I've ever seen. The evidence to reflect that Mr. Baruch failed to accurately disclose his interest on his 3 forms is clear and convincingly present. Thank you.
Thank you, Ms. Hadley. Mr. Herron, you have a few minutes left if you wish to use that. You're welcome to do so.
I think the clock stopped at like 4 minutes and 4 seconds when I sat down. 4 minutes is close enough.
You got 3:58 now.
That's all right. I don't think I'll need it. Don't know exactly where to start, but I will start with some words that the advocate said in her argument. She said, all the form is doing is asking somebody to disclose by street address. She said asking. Does that mean asking? No, but the argument that is being made by the ALJ and adopted by the staff is that this word mandates the use. Advocate in an argument said asking. With respect to The ALJ's, I guess now, interpretation of what location means, that's not in the rule. That's his interpretation now, that you can describe it by meets and bounds or some other way. That's not in the rule. That's not on the form. It says street address. You're bound to now guess what location is. I know in preparation of this case, I asked a representative of this commission, are you allowed to use a meets and bounds description? I don't know, was the answer. I don't know. With respect to the comparative threshold versus the comparative value versus the monetary threshold, failure to check the box, there was no evidence at the hearing that that impacted any of the disclosures in any way. I already addressed, I believe, the issue in my presentation about the number of the properties now disclosed on the Form 1Xs. Again, it's because the descriptions of the locations in a plat or the locations in a subdivision were expanded in 2019 to include all those street addresses that may or may not have existed when the forms were originally filed, because there was no evidence of that presented at the hearing, that these things had a street address in 2014, 15, and 16. The last statement by the advocate about this is the worst case ever in terms of Form 1 is a bit of hyperbole. Because again, if you look at the properties, if you look at the descriptions, and if you have reviewed the record and you have seen the Form 1 disclosures, you will see there were disclosures. And I would think the worst of one would be somebody that leaves something off and doesn't disclose it. Carlos Baruf did what he did in 2014, 15, and 16, consistent with the practices that he was understood and was advised by his staff to follow. He had filed forms for years and years. No one ever addressed it. I believe in his testimony, and this is the last thing I'm going to suggest, is that somebody needs to check these things. And perhaps maybe when we get to the electronic filing of Form 1s, it will self-correct and self-check. But again, there will be at times properties that do not have street addresses. And it needs to be addressed. And again, Carlos Baruf complied with the law, complied with the requirements of the law, the extension, enlargement of the requirements of the law through the rule. It was an invalid exercise of the rulemaking authority of this commission. Thank you very much. Appreciate it.
Thank you, Mr. Herron. Ms. Hadley, you're recognized to respond.
Well, I mean, you're in charge, Mr. Chair, but I don't think.
I'm sorry?
You're in charge of this meeting, Mr. Chair. I understand that. But again, she didn't ask to reserve. And anyway, hers replies to mine. I asked to reserve.
Well, she has some time left over, and I'm going to allow her to use that.
Short clarification. I said since I've been handling cases, that's the worst case I've seen. Also in the Joint Exhibit 3, that is the directions for the CE Form 1. And under Part C, real property, it says the location or description of a property should be sufficient to enable anyone who looks at the form to identify the property. A street address should be used if one exists. If a street address doesn't exist, that means another form of description should be used. The ALJ found that Mr. Baruf failed to use any form of description to identify those properties. He simply put, for the majority, multiple lots. That would enable the public to find it. Thank you very much.
Thank you, Ms. Hadley. Members of the commission, before I open this for questions and deliberations and so forth, let me just suggest to you that we have several alternatives. One, we may take up the exceptions and vote on them one by one. If somebody wants to accept or reject those exceptions, they can so do. Or the commission can handle all of this by adopting the staff's draft order, which addresses all the exceptions and all the findings and all of the conclusions. So before I take any motions, I want to allow members of the commission any discussion or observations they wish to make.
Question?
Commissioner Gates.
Thank you, Mr. Chairman. Is it proper for me to ask a question of the advocate, please?
Yes, I would think so.
Ma'am, counsel for the respondent used the term innocent mistakes to describe some of what occurred in this matter. And you, as I heard it, suggested that there was knowing intent to either omit or knowing intent to omit information that was legally required. So I'm asking if you'd clarify that, or if I misunderstood. On the one hand, innocent mistakes. On the other hand, a knowing intent to violate. Are you suggesting that there was a knowing intent to violate, or do you have any comment as to counsel's description of this matter being, at least in part, innocent mistakes?
So I do want to clarify, intent is not an element, so I did not, or it wasn't required that intent be proven. So I just want to clarify, I did not say that it was he knowingly intended to omit any items. That's not an element, so it wasn't required to be proven. So as the ALJ, including it in her order, that intent isn't required, so just want to clarify that with you. So knowingly isn't required, that he knowingly admitted.
Having said that,
Yes.
would you please answer my question? And my question was, in your view, this matter's gone on for 5 years, so there's been a lot of time to, examine the entrails of this issue. In your view, as the advocate, was there intent to violate?
So,
Leaving aside the
Okay.
question of what the ALJ may or may not have found.
so I don't know if there was intent to violate because it's not required, and because it wasn't a requirement element to prove. So the reason why this case is going on is just that there were discussions about possibly stipulating at one point, and then pandemic happened, and then we moved forward when we could. What I will say is that any of this, all of this, these failures, they're not de minimis. That was an argument that was presented to this body, that these were de minimis. They're not de minimis. And again, it doesn't, whether he intended to or not, isn't a requirement. It doesn't matter. It is what it is, whether he failed to disclose these items properly. Some he failed to disclose at all, some he failed to disclose properly.
A follow-up, Mr. Chair?
You're recognized.
Thank you, Mr. Chair. You classified this as the worst case in the area of financial disclosure that you have seen in your time with the commission since 2009. And the penalty that is being recommended today is $1,500. $1,500 is real money, but it's not much money. Would you, in your view, if this is the worst case you've seen, does the penalty properly reflect the worst case description, the gravity of the matter?
As I argued before the administrative law judge, I argued for $5,000 per violation. There is a history of violations of 112.3145, and those were disclosed in my argument, and as a matter of fact, the administrative law judge included that in the final order. However, those cases were stipulations where there may have been 1 to 3 disclosure inaccuracies. This case, there were more. So I argued for $5,000 per violation. The commission, the ALJ gave the benefit of doubt and just did $500.
And a final follow-up, and then I
You're
apologize,
recognized.
Mr. Chair. Do you believe that there is that there's adequate basis for a different penalty than the one that is being recommended.
I believe that based on what I argued before the administrative law judge, is that this case is distinguished from the other ones, that there is an adequate basis.
Thank you, Mr. Chair.
And to be clear, the other ones that had a $500 penalty.
Commissioner Carvajal.
Thank you, Mr. Chair. I'm not sure whom I'm directing this to. I don't think it's the advocate. It might be to our counsel. But I just may not have found it properly in the recommended order. My understanding to the core of exception 4 is the argument is that everything was reported, but in a broad stroke, and therefore captured more than possibly the properties that were to be designated. That the number seems different simply because in the first report it just said multiple lots, and in the second it detailed the number of properties. So here's the question. Was everything reported but just captured too much, possibly things that are hard to distinguish or not? Or the other way, which is still a violation. I will acknowledge we have ruled in those directions in the past that being overly general or capturing things that shouldn't be captured may still be violation. So I just want to make sure that everything that was his property was listed, but it's possible that more was captured by the description. And I'm not sure who to direct this question to, because it may go to the matter of fact, and therefore I might challenge what the ALJ said.
I'm going to recognize our general counsel.
Thank you, Mr. Chair. Commissioner, your question about the fourth exception, I think it's addressed in paragraph 61 of the ALJ's recommended order. In paragraph 61, the ALJ finds that on the 3 Form 1s, respondent failed to adequately list the location description of the properties. It's argued that the 35 line items included all of the 740 properties that were disclosed later. That's the sum of respondent's argument and the exception. It's, to summarize the other argument, if you got a bank statement and we're looking for an accurate reporting of what was in your bank account and it just said money, you might be disappointed by that description, because sure, you have money in your bank account, but you want to know a little bit more than that. And that's what the ALJ found, that the reporting did not rise to the level of what was required in the law.
For a follow-up, just to clarify.
You're recognized.
And I appreciate the council trying to use an example. Let me use the example that you used so that we can stray a little from this. But if I had an account that had 5 sub-accounts and I listed at the very top the total of those 5 sub-accounts, but I didn't detail each of those 5 sub-accounts, I'm still reporting the money, just not the 5 sub-accounts. Is that what happened in this case?
It appears to be her finding, not that they were not, she's not saying, as far as I can tell from the ALJ's recommended order, she's not saying that those properties might not have been included when it says multiple lots at a particular subdivision. What she's saying is that he failed to adequately list the location and description of those properties.
Thank you, and I appreciate the extra courtesy in that, because what I'll be arguing is that they were covered, but I will absolutely agree that they were not adequately listed. So,
Are there further questions or discussions by members of the commission? None appearing, do I hear a motion? And I again remind you that you have several options. One is to vote on the exceptions, each one at a time, or you have the option of adopting the staff's draft final order, which encompasses everything.
I would make that motion.
Is there a second?
The motion is latter?
Which motion?
Yeah.
Didn't follow that.
The latter.
Okay, the commission, your motion is that the commission adopt the staff's draft order, which addresses all the exceptions, finding, and conclusion. Is that correct? All right, is there a second?
I will second that.
Commissioner Carvajal seconds. All right, is there discussion? Commissioner Walden.
Thank you, Mr. Chair. It's interesting, my wife, the word should, I have to say this, my wife, every time I tell her what she should do or somebody else should do, she always scolds me and says, you never should tell people what they should do. You may want to suggest that they may do this, but you shouldn't be telling people what they should do. I find that Mr. Herron's argument is very persuasive. I agree. I keep looking at these, at the description of the properties and understanding that Mr. Baruf is a developer, and I do not know Mr. Baruf at all. Wouldn't know if he was sitting in front here or anything. But as a son of a developer, I see this, and these descriptions are descriptive enough. And I think that Mr. Carvajal's analogy is correct. If you have a bank account and you list the total, but you don't list those sub-accounts, you've described pretty accurately, in my opinion, what needs to be done. As it relates to the addresses, and as I said, my father was a developer for 50 years, these are descriptive. When you put multiple lots down, at that time, you probably don't even have a street address. And the whole idea of the financial disclosure, as I understand it, is to list property that's adequate, using Mr. Carvajal's word again, adequate to locate the property. And that does not necessarily mean that specific. Of course, if you have a house on the property, that's easy to list with a street address. But when you're a developer, the property itself can actually span counties, and it can go into different cities. It can do all kinds of things. But the idea is to disclose what's there. And as I look at it, and I looked at all the years, they're accurate. While it may sound like 1,000 acres at 1403 State Road 44 Wildwood is a big property, I venture to say that they're not all at 1403. Some may be 1408, and some probably are 1,500, and maybe the numbers go beyond. This seems to me to be a situation where somebody decides to take advantage of a financial disclosure to file a complaint against somebody. And as I said, I don't even know Mr. Baruf. He's a volunteer on these boards. So I find that having to use a street address should not be a requirement that we have. And I said should not. As it relates to the checking off the box, that's just, look at it, I mean, that's just a ministerial error. He could correct it, and in fact, I know you can correct it because I did it myself. One year I failed to list what I did, whether it's comparative or the dollar amount. And so somebody could have filed a complaint against me, and in spite of the fact that every year I've ever done it, I always did comparative values. So that being said, I'm opposed to the motion. I find persuasive what Mr. Herron has said. I think we are exceeding what our authority is by requiring a street address when the wording says should and it does not say shall. Thank you.
Thank you, Commissioner. Further questions or observations? Commissioner Gates?
Thank you, Mr. Chair. What Representative Waldman says recalls to me a case that did not come before the commission, but it was a complaint that was filed. And the complainant said, here we have a public official who has listed a property that he says he owns at this address. And we have determined that that property is not at that address. And so therefore, we're going to file a complaint that he's misled the public. I know something about that case because I was the public official. It never got to this commission because it was dismissed out of hand as not having proper basis. But what happened was the developer changed the addresses. The county changed the roads. So an address that was valid 1 year was no longer valid the next year. And in this particular public official put the proper address down, put the new address down, but the complainant thought that, or believed that, that there was a misleading information because the old address no longer was put on the financial disclosure. My point is simply that Representative Waldman is right. I think that in developments, things change, addresses change, name of roads change, numbers change. And even after a development is completed, there still can be changes of numbers and street names. And so therefore, I think we need to be careful that in cases like this, and I'm not sure, I'm not trying again, this went on for 5 years, so there was plenty of time to look at everything. I'm just suggesting that in cases where you do have a developer involved, you need to be very, very sure that, that the use of street addresses isn't the only way that you identify a property, and that you can use other ways to identify a property, and that those are accurate at the time, but they may not be accurate a month from now.
Commissioner Carvajal.
Thank you. I'll be supporting the motion as it stands, and I just want to express a few things because first, the AL judge was the one who used the term adequately, and I'll accept that as that description. I appreciate the credit on that, but I am assessing this in context. The respondent served on the Water Management District, and some of these properties may be very large, multiple lots may be a very broadly encompassing item. So the public deserves the right to know if somebody is making decisions based on interest, and I get that multiple lots is not enough. So I do agree that there's some violations, but I don't think it was egregious. I do think that the moderated penalty seems to fit where we're going. Be it de minimis or not, this could have been hundreds and thousands of dollars potentially, but I think it's fair for what we've got. It makes a statement. And just to go back to the analysis that of the bank account that I had with the general counsel, the sub-accounts may actually matter significantly if 5 of them roll up to the bank account, but one of them was for illegal trafficking or terrorism or something like that. The sub-account would absolutely matter. I believe that in this case, the respondent reported the properties, but not sufficiently. I stand by what I'm reading in here, even if it's a bit confusing to me at times. And I think the violation is noted and the amount is sufficient for what is happening at the moment.
Further discussion? All right, I'm going to call for the question. All in favor of Commissioner Megg's motion, say aye. Aye. All opposed, like sign?
No?
It passes. All right, thank you. That takes us to the next item, in Ray Tolsey's. Here again, we have a recommendation in the form of an order from the administrative law judge for the Division of Administrative Hearings in Ray 20-10, David Tolsey's. It recommends the commission find the respondent violated section 112.313, paren 6, Florida statutes, and for that violation, a penalty of $2,500. Both the respondent and the advocate timely filed written exceptions to the recommended order, and then they filed responses to those responses to exceptions. And they were all included in our meeting materials. We do have a draft final order printed out, and it analyzes and rules on each exception and adopts the recommendation of the administrative law judge. Is there anyone here for the respondent?
Mark Heron on behalf of David Tosis.
Thank you, Mr. Herron. All right, we will give Ms. Miller an opportunity. She has 15 minutes. She may reserve unused time.
Yes,
And then,
please.
Mr. Herron, you will have a like amount of time, and you too may reserve unused time. Ms. Miller, you're recognized.
Thank you. I would like to reserve any remaining time. Good morning, Commissioners. Elizabeth Miller, advocate for the Commission. I filed one exception in this case. I'm requesting that the Commission amend the penalty to include a public censure and reprimand. This is not mandatory, of course, that you include a public censure and reprimand as part of the penalty, but it is certainly appropriate in this case, as well as any other case that involves a violation of the misuse of public position statute, where corrupt intent is an element. This is the most egregious offense of all the ethical violations because it does have an element of corrupt intent. In this case, the totality of the facts require a public censure and reprimand because the respondent's conduct detrimentally affected the integrity of his public position. The respondent placed his personal enrichment for himself and that of his law firm above the public's welfare. A public censure and reprimand, along with the recommended monetary penalty, would sufficiently address respondents' ethical misconduct and act as an effective deterrent. This request is certainly not unique. The Commission has fairly recently considered amending the penalty to include a public censure and reprimand. In the Robert K. Robinson case, you included a public censure and reprimand when the attorney was found to have misused his public position from the dais. That's exactly what happened in this case. I request that you adopt my one exception. Thank you.
Thank you, Ms. Miller. Mr. Herron, you're recognized.
Mr. Chairman, members of the Commission, Mark Heron representing David Tosis. I will probably address Ms. Miller's exceptions in the consideration of my exceptions, and so I don't want to flip-flop back and forth on that. So let me just kind of go with what I'm going to do. In this case, the Commission will note that we filed 21 exceptions, and the problem with the administrative law judge's recommended order is that the finding of fact with respect to paragraph 26 essentially affects a score, perhaps, of conclusions of law and findings of fact. And so I have never done that before, that many exceptions, but we've tried to address it because, again, it's affected the entire recommended order. In my presentation, I want to address 3 issues, and I will tie it to various exceptions. And again, like I did in the prior case, in the event I do not address those here today, there is no intent to waive argument on that. We would rely on our papers. The first exception, again, deals with the interpretation of paragraph 12 of the RFP. This is really the central issue in this case because it drives a number of other exceptions, a number of other paragraphs of the administrative law judge, and it's going to drive a number of the exceptions. And again, I want to look at first now exception number 45 in our papers. And I'm sorry, exception 26. I'm sorry, exception 26. It's on page 3, and then I'm going to go to exception 45. Finding of fact 26 erroneously construes paragraph 12 of the RFP by parsing its provisions and construing them in isolation contrary to well-settled canons of interpretation. We've cited 2 cases in our paper. One case involves a statute, and the case says that a statute should be interpreted to give effect to every clause in it and to accord meaning and harmony to all its parts, and should not be read in isolation, but in the context of the entire section. With respect to a contract, it's similar law, and pertinent provisions of a contract should be interpreted as a whole, viewing all words in context. Provisions should not be interpreted in isolation. And that's what the administrative law judge did in paragraph 26. And he could only reach his interpretation by deconstructing the provisions of the paragraph and viewing them in isolation. Read as a whole, paragraph 12 prohibits private communications between proposers and identified BCH members, Broward County Housing Authority members. By its plain language, paragraph 12 as a whole prohibits private or personal communications between proposers and BCHA staff, any member of the Board of Commissioners, any member of the Board of Directors, or the Audit Committee, except to the point of contact. All of the prohibited modes of communication suggest communications in private, outside the public view, and contrary to the purposes of the competitive solicitation and restrictions against lobbying. This interpretation is consistent with the testimony at the hearing. Ann Diebert testified that she interpreted the provision as prohibiting private communications only. Respondent, Mr. Tolsis, similarly interpreted that provision. Multiple members of the Board of Commissioners believe that Mr. Tolsis had a right to speak about the procurement at the May 19th meeting. And again, he spoke at a publicly agended meeting. Wasn't any private communication. Even the person who objected, and again, if you looked at the video, when you're in review of the record, the person that objected believed that respondent speaking, he believed that he had the right to address the board about the RFP. He just did it in the wrong part of the agenda. He should have done it in a public comment. None of the witnesses' testimony or evidence suggests that respondent violated paragraph 12 by speaking to the entire board at a public meeting. So this particular finding that's in 26 then is carried over into other particular paragraphs of the administrative law judge. Paragraph 45. Again, the same issue arises there when the ALJ erroneously concludes that paragraph 12 of the RFP did not permit these types of comments to be made since the final award had not been yet made. Again, that ignores the evidence that a person can speak at the board because the paragraph 12 did not prohibit it. And again, several board members, including the chair, staff, respondent, and another individual who was attending the meeting, interpreted paragraph 12 as not prohibiting the respondent from speaking to the board at a public meeting. Again, this rolls over into conclusions of law and or other paragraphs, and I'm going to relate to paragraph 57. Paragraph 57, the administrative law judge did something that was really tricky in our view. The administrative law judge essentially disregarded the testimony of the BCH staff as to how they interpreted paragraph 12. While the administrative law judge disregarded the testimony of Ann Diebert and Tisha Palmer about their interpretations of the cone of silence, their unrebutted testimony established that paragraph 12 did not clearly and unambiguously prohibit the proposer from making comments to the board about the RFP at a duly noticed public meeting. Ms. Palmer testified that the cone of silence ended at the time of the evaluation committee made its recommendation. Ms. Diebert interpreted the cone of silence as ending at the time of the final award. However, she also testified that the cone of silence only prohibited private communications between a proposer and the Broward County Housing Authority, and that it would be appropriate for the proposer could speak during public comment. So the point being is that paragraph 12, the key to this whole case, is interpreted by a whole different people, a whole different ways. It's not clear, it's not unambiguous. I'll move on to the next point that the next issue I want to address, and that's the meeting itself. The meeting itself, again, this whole thing is couched in the terms of Mr. Tolsha should have come down from the dais, come down here and made a presentation to the board. That may or may not have been consistent with the paragraph 12, but the picture that's painted by the ALJ is that there's a dais, and he could come down and make a presentation. This was a Zoom meeting. There is no dais. Everybody's a little bitty box. Again, if you looked at the video, you'll see the little bitty boxes. And so anything that's talking about the nature of the meeting being some kind of coming down from the dais and making a presentation is not accurate. I'm going to move on now to paragraph 49, exception 49. That deals with the same issue. No, I don't have it. Sorry, I don't have one for 7475 is where I want to go. This is the issue that I think people, advocate, administrative law judge, kind of focus a little bit on with respect to corrupt intent. And our point is that there's no competent substantial evidence in the record to allow the administrative law judge to reach the conclusion that the chair allowed the respondent to speak because of his influence and official position as the board attorney. The only direct and unrebutted evidence as to why the chair permitted the respondent to speak came from the chair himself, who testified that he had never prohibited anyone from speaking on an agenda item. The chair's practice was to allow 3 minutes during public comment and 3 minutes during the agenda item. Mr. Tolsha spoke at the time the agenda item came up, which was right after public comment. So this evidence of intent based on the fact that he used his position to do that is kind of belied by the testimony of the board chair and why they allowed Mr. Tolsha to speak. Now, what did Mr. Tolsha's request, and why, again, back to his ability to speak? At paragraphs 86 through 87, conclusion of law 86 concludes that respondent's intent was corrupt in that he sought to completely waylay and undermine the work of the evaluation committee and restart the procurement process, which was nearly completed. This is one of these strange cases where, and I hate to criticize ALJs, but I don't think the ALJ really focused and gave independent thought to this. If you look at the recommended order that was submitted by the advocate, and you look at the proposed order, it's almost identical in my cousin Vinny terms. It's almost identical. And so it's as if we didn't show up for the hearing. But the evidence in the record with respect to intent, and it's in finding of fact 43, which there is no exception filed, says this. Respondents, well, I'm going to paraphrase to a certain degree. Respondents' comments were limited, and as evidence in finding of fact 43, he never completed his comments because of the interruption of Mr. Kojic and the abrupt decision of the board to recess the meeting. Respondent only asked for one thing only. He asked to be heard and he asked that the Board of Commissioners review the proposals themselves, review the evaluations that were conducted, and come to their own determination based on 3 factors: the amount of years, 15 years of experience with the agency, my knowledge of Broward County, and the presence of a local firm, and that's when the interruption came. There's no evidence that the respondent sought to completely waylay and undermine the work of the evaluation committee and restart the process. As explained in exceptions to paragraphs 84 and 85, respondent did not improperly seek a special privilege or benefit for himself or his law firm by requesting at a public meeting that the Board of Commissioners review the proposals themselves, review the evaluations that were conducted, and come to their own determinations. I'll stop there and reserve my 1 minute and 40 seconds left, and if I need to come back, I will. Thank you.
Thank you, Mr. Herron. Ms. Miller, you've reserved your time.
Thank you. At the time when respondent spoke, the evaluation committee had already made its recommendation, and it was not respondent and his firm. He took the advantage that no one else had to try to negotiate for himself and his firm. No other proposer did that. The other proposer, in fact, was the one who filed the complaint because he knew it was incorrect. As far as paragraph 12, let me tell you why Ann Dibert, the chair, staff, a member of the public, or anyone else who read this paragraph as Mr. Herron reads it, why it doesn't matter. Because Tolsas never, ever asked any of them, how do you interpret this paragraph? He interpreted it himself. But in addition, the people who I just listed off, none of them are lawyers, not a one of them. However, Mr. Tolsas is a board-certified local government attorney. He is held to a higher standard as board-certified. He testified that this was not the first cone of silence that he had read in a contract. It doesn't matter where Mr. Tolsas was. He could have been at the dais, he could have been on the street, he could have been at the podium, he could have been at Disney World. It does not matter at all where he made these comments. He was restricted by paragraph 12 to not speak to certain people about the evaluation and the process. Yet he did. He spoke to those same people in an effort to persuade them to open up the evaluation again and consider him based on his record, his experience, so on and so forth. Before his comments, he did identify himself as the board's attorney. And I would just like to say, in reference to paragraph 12, everyone seems to confuse the subject of each sentence. And if you break it down, you will see that he was not, as a proposer, to speak to the board about this subject. Thank you.
Thank you, Ms. Miller.
A question. Can I ask a question?
I'm sorry?
I'd like to ask a question.
Oh, certainly.
Ms. Miller. Thank you, Mr. Chair. So the position you're taking is regardless of whether it's a public meeting or anything like that, cone of silence means once you put that bid in, you can't talk at any meeting, you can't do anything, because to any of these people who are at a meeting can't hear anything from you once that happens. Is that how you interpret cone of silence?
It ends on a specified date that was put in the instructions to fill out the application. He knew the date because he was told the date in the instructions when he could speak about this. Yes, but that is my interpretation. It is an unfair advantage for him that no other proposer got. He took advantage, and he should not have done that. And I'm sorry.
No, go ahead. I didn't mean to interrupt you.
If there isn't a cone of silence, and there is a cone of silence usually in contracts, definitely in state contracts or county contracts, but there's also a cone of silence in the statutes. Mr. Tulsa's interpretation of the cone of silence would just eviscerate any cone of silence in any contract. He spoke when he was not supposed to speak. He had alternatives. He could have used the alternatives to speak to members of the evaluation committee. He chose not to do that.
Follow-up?
You're recognized.
And so what alternatives were those?
He could, if I may through the chair, he could put in writing to the manager or the procurement manager. He could put in writing his questions. Those questions are then published for the other proposers so that everybody's on the same page.
So follow-up?
Certainly.
So if you ask a question in a public meeting, wouldn't everybody be on the same page at that time? Everybody hears it at the same time, and you've asked that question, or you've made a statement, then everybody has that opportunity, is the one thing. But then the other, so you're saying, so nobody, so even the other bidders, they couldn't have spoken at that meeting as well?
Through the chair, that is absolutely correct. The procedure was not followed in this case, and there is a definite procedure. Now, if I may, they can speak about anything they want other than this RFP process.
Okay. And then to my first part of the question was, isn't what you're accomplishing in a public meeting the same as everybody has an opportunity then to respond at that time? I mean, that's the whole purpose of the public meeting, so everybody can hear what's going on, everything's done in the public. I always thought the cone of silence was to make sure that people didn't do things behind closed doors and all.
In this case, first of all, he was not asking a question. He was asking that the process be reopened and that the board consider him. The evaluation had already been, the committee had already made its recommendation, and as I said, it wasn't him. He was given 2 opportunities to speak in public. Through the evaluation committee, they had a private meeting and then they had a public meeting where he could have and did, in fact, take the opportunity to speak then. And that's the time he would promote himself. But he can't promote himself outside of this evaluation process. The rules and regulations do not allow it. And he signed the document stating he would follow the rules and regulations of the proposal.
And just one final follow-up, and I apologize.
You're recognized.
So how, though, do we get past the first sentence, which says, in order to maintain a fair and impartial competitive process, BCHA shall avoid private communication concerning this procurement? What is private about a public comment in a public meeting?
Well, the subject of that sentence is BCHA. That's the board. And they should avoid, the board should avoid private comments. Now, had they asked a question, that would have been acceptable, but they did not ask a question. He spoke up with prepared remarks, proposing himself.
I apologize. I guess this always happened in the legislature. You'd say one, it's my final question, and then you just keep going on and on. But I apologize again, but.
One more.
But it just, but that doesn't, that's kind of circular, what you're saying. I mean, the whole concept behind this is not to have private communication with the board. And this is directive at the board, so the board members, in fact, if the board members were contacted, they better disclose that at the beginning of the meeting, much as we do disclosures of whether we know anybody. But the concept here is things should not be done in private communications with BCHA. Nothing says you can't publicly communicate with them in a public meeting. I don't see it anywhere in this paragraph 12, administrative terms and conditions. And I can't get over that. And in all the years that I've been in public service, and there are quite a few, my understanding of cone of silence was to prohibit those private communications, not what's stated in the public. In fact, we want the public to know everything that's going on. I know for those of us who are elected officials, former elected officials, that's what we always wanted. So I can't get by that. That's the whole thing. Now, I don't know how that plays into everything in terms of the exceptions and where we go from here, but I have a very difficult time understanding why the cone of silence applies in a public meeting.
If I may.
You recognize?
Thank you. Mr. Tolsis was a proposer. Proposers are not allowed to communicate about this RFP for any reason with any BCHA staff, any member of the Board of Commissioners, any member of the Board of Directors, so on and so forth. But he can, if he has a question or wants to say something, put it in writing and go through the appropriate channels. Then at the end, the very end of this paragraph, if the respondent has any reason or not related to the RFP, then he can speak about it. But the facts or the procedures around the RFP are to remain silent until a particular time that's specified in this paragraph.
That was really it.
Thank you, Commissioner. Are there further questions of the advocate? All right, Mr. Herron, you have 1 minute and 40 seconds.
Thank you. Just a couple of responses to what you just heard. One of the points that we raised in the hearing was that Mr. Tolsis had an opportunity to speak pursuant to Section 286-0114. And that's the opportunity of citizens to speak at a public meeting. In fact, at the beginning of this meeting, I believe the chair announced that people could speak on certain items. And so Mr. Tolsis, in terms of speaking, also relied on that. The draft final order says this commission can't really construe that, and we'll leave that for another day. I believe that, and you were told, I believe, that the person who filed the complaint here was Mr. Tolsis, represented a law firm that was Mr. Tolsis' competitor. And he was on the Zoom, and again, consistent with the questions that were asked, he probably could have said something if he wanted to. He felt that he couldn't. But again, he's Mr. Tolsis' competitor. With respect to the public censure and reprimand issue that was brought up, we would ask that you do not adopt it. Mr. Tolsis is not necessarily, the administrative law judge heard all the evidence, he made the recommendation, and he did not recommend a public censure and reprimand, and I would ask that you not add that to the penalty. Thank you very much.
Thank you, Mr. Herron. Okay, members, commission, this is very much like the last one that we had. We have a proposed recommended order by the administrative law judge. We have an exception that has been filed by the advocate, and we have, how many, Mr. Herron, 21?
21, yes.
21 exceptions that have been filed by the respondent. We can take each of those 22 exceptions and vote them up or down individually. Or we can take a motion by adopting the staff's draft order, which addresses all of the exceptions, all of the findings, and all of the conclusions. And as we did in the last case, we can vote that up or down. So I am open for a motion from a commissioner. Commissioner Gates.
Thank you, Mr. Chairman. To get the matter before us, I move the staff's recommendation in all of its parts.
I will second that motion.
Commissioner Gates, Commissioner Carvajal, thank you. Now,
Mr. Chair, can I ask a question?
certainly.
Does that also include the public censure?
Mr. Chairman?
It does.
Yes,
Okay,
sir.
I just wanted to make sure.
Yeah, everything.
Actually, point of
that has been-
clarification, the draft final order, does that include the censure?
We did not grant that exception in the draft.
So that was just a clarification. There is no
Oh,
censure
okay.
in the draft final order.
Okay.
Mr. Chairman, then, with the permission of the seconder, I'd like to withdraw my motion so that I may properly state a motion that would put the matter entirely before us. And that is that, with the secretary's permission, I would withdraw my motion and move that we adopt the staff's recommendation and the advocate's exception.
Is that agreeable, Mr. Carvajal?
It is, I'll oppose that next motion, but I would always defer to you on that, so.
All right, so we have before us a motion to approve the commission's draft order with the addition of the public censor.
Yes, sir.
All right, is there a discussion?
Is there a second?
I'll second it.
All right, Commissioner Ankers seconds the motion. Is there discussion? Commissioner Carvajal?
Just for clarification, I understand the word censure, but I don't understand the implication in this particular case of what a censure would cause. Particularly since the individual is an attorney, I'm not sure if anything happens in other domains or if this is just an extra slap of the hand and a recognition that something shouldn't have happened.
I'm going to ask our general counsel to respond.
When the penalty is imposed, if you do indeed impose a penalty, or recommend that a penalty be imposed, when the governor goes to impose it, the executive order will say what the penalty is, and it will say he's also publicly censured and reprimanded, if that's what you choose to do. As far as what happens in other forums, we wouldn't be able to speak to that. Historically, I don't think it affects anything else in other forums like the Florida Bar, but I wouldn't dare speak for them.
Further discussion or questions? Commissioner Walden?
Thank you, Mr. Chair. I don't know if my speaking helps or hurts, I guess, but I can't keep quiet on this because, I mean, as I explained, I mean, you can't get, just the plain meaning of paragraph 12, you can't get past the fact that this has to do with private communications. It has nothing to do with comments in a public. Now, he may have stated things at the wrong time, and he could be very well guilty of that he shouldn't have spoken at a certain time, he should have waited or whatever. But you can't get by the fact that the cone of silence, as it's being interpreted here, doesn't pertain to a public meeting. That makes absolutely no sense. That's the whole concept behind these processes, is to put everything out into the public. So that's what we're having for. So I'll oppose it certainly because of the censure, and I hope that maybe I have another vote with opposing the motion because of adding the censure, but I don't know. But I just can't get by the plain meaning of what that paragraph is. Maybe that's my training as a lawyer, but it doesn't make any sense to me at all.
Well, Mr. Waldman, let me clarify. The censure is on Mr. Gates' motion.
Correct. No,
We're not having a separate vote on the censure.
Right, I'm hoping that, that this one will fail.
Oh, okay.
And then maybe it'll come back again without the censure, so
Okay.
it's not as
All
bad
right,
as it is now.
I just wanted to clarify that.
I got it. Thank you.
All right, is there further discussion? Commissioner Carvajal?
Thank you. I know a lot of attention has been placed on the cone of silence. And, but I am more moved just for the case of the inappropriate time to speak, and moved, and I didn't see it necessarily in the evidence, but just so that it's out there, what moved me is when somebody else tried to speak at that same time, the chair actually did shut down the meeting. So regardless of intent or anything of that sort, speaking at the wrong time actually could have been shut down. So I'm moved that there was a misuse of public position in this case. I'm not smart enough to understand what censure does in the rest of the world, but I'll support the motion as it stands if needed.
Further discussion? Commissioner Gates, you want to close on your motion?
Does sir. Representative Waldman closed for me.
All right. All right, all in favor, say aye.
Aye.
All opposed, like sign?
No?
All right, and show it passes. All right, that takes us to the, thank you, Mr. Herron. We appreciate your being here as always. I'll be around. I'm afraid of that. All right, our next item is consideration of final action on a pre-probable cause stipulation, complaint number 17-180, and Ray Woodrow J. Latvala. This is a pre-probable stipulation complaint, number 17-180. And before we begin, I have a disclosure to make. I'm going to pass the gavel to Vice Chairman Gilzine, because under Section 286.012 of the Florida statutes, I'm going to recuse myself from consideration. I'll not participate in any way due to my longstanding personal friendship and relationship with the respondent. Mr. Latvala and I have been friends for many years. He actually recruited me to run for office 40 years ago, and we subsequently served together in the Senate. I consider him to be a good friend. Notwithstanding that, it would not affect my vote, but so there would never be any appearance of impropriety. I am going to step aside and turn the gavel over to Commissioner Gilzine.
Mr. Chair. Mr. Chair, I similarly have a disclosure to make. I served with Senator Latvala in the Senate. We at times had a publicly antagonistic relationship that I don't believe is a secret to anyone. And consequently, I don't believe that it would be fair to Senator Latvala for me to vote on this matter. I have had a conversation with our general counsel, and he's informed me that by the authority granted by 286.012 of the Florida statutes, the same citation that you gave, Mr. Chairman, that a member of the commission can abstain from voting and participating in a matter to assure that its proceedings are fair and appear to be fair to the parties and the public. Therefore, to assure a fair proceeding for Senator Latvala and the appearance of a fair proceeding, I will be abstaining from any consideration of this matter.
So recognized, let me make the observation, as you know, we have two vacancies on the commission. And with two recusals, that takes us down, Commissioner Gilzine, to 5 people. So we barely have a quorum. You're in charge.
All right, all right. Are there any other members who need to make a disclosure?
Mr. Chair.
All right.
Thank you, Mr. Chair. I do know Senator Latvala. I served in the House of Representatives while he was in the Senate. We're not personal friends. We're friendly with each other. We're acquaintances. It will not affect my vote at all to participate in this.
Okay. Sir?
Thank you, Mr. Chair. I am familiar with the respondent and a number of the individuals referenced in the report of investigation. It will not affect my decision. I intend to participate in the proceedings.
All right. Any other member? So I do want to also disclose that I do know the respondent. 20-something years ago, when in college, I was a fresh college intern that wanted to get into the political process, and I knocked on doors. But I haven't seen the respondent nor talked to them over 20 years, so it won't affect my ability to preside over today's case. All right, members, counsel for the respondent, we've already did that. So we have before us a pre-probable cause stipulation between the commission, advocate, and respondent. This matter is being considered in the public session because of the respondent in signing and filing a pre-probable cause stipulation waive confidential. Okay. So I do need to do that. Okay. Kitty jumped ahead. Of course, Senator President, we'll always jump ahead. So members, let me see. The counsel for the respondent timely filed a motion to disqualify Commissioner Gate for participating in the consideration of this complaint. An affidavit stating the particular grounds for the request accompanied by the motion. Under Rule 34-5.017, Florida Administrative Code, commission members shall be disqualified from sitting as a member of the commission at either the probable cause hearing or the final public hearing for bias, prejudice, or interest. If the motion and the affidavit are found legally sufficient, the motion must be ruled upon the commission members who disqualified South. So because he's already said it, now is the time for us to vote on that, or he
Well,
just,
Mr. Chair,
gotcha.
Recognize him.
Mr. Chair, thank you. Counsel for the respondent has, as you pointed out, filed a motion to disqualify me from considering this matter. I've reviewed the motion and the affidavit that's attached to it. Our general counsel has informed me that under Rule 34-5.017, Parent 3 of the Florida Administrative Code, I'm the person who must rule on this motion. My ruling shall be based on the legal sufficiency of the motion and the attached affidavit. Given that I will be abstaining from this matter under Section 286.012, as I mentioned earlier, I find that the motion is moot. I rule that therefore it should be denied. Thank you, Mr. Chair.
We have before us a pre-probable cause stipulation between the commission advocate and respondent. This matter is being considered in the public session because the respondent in signing and filing a pre-probable cause stipulation waived confidentiality. After considering all the materials and presentations of the parties, the commission may vote to approve or reject the stipulation. As this is a pre-probable cause stipulation, if the stipulation is rejected, we will go immediately into a probable cause hearing on this complaint. Complainants have the right to comment in writing on proposed stipulation. We have not received any comments from the complainant in this case. The advocate, you will now present the stipulation.
Mr. Chair,
Yes, ma'am.
late yesterday, we did receive a response from the complainant. It was past the deadline, but we do have it available here for your review, and Millie can pass that out if you would like.
Okay. Yes, I guess, yes, we would like it. So please pass it out. Madam?
Thank you. Elizabeth Miller, advocate for the commission. This case involves the respondent, who is a former Florida State Senator.
We
And
hold
it-
just one sec. I just hate for Ms. Miller to be distracted while we're getting this.
Thank you.
Thank you.
Mr. Chair, and this may be to the director, since this is late filed with us, has this been posted publicly?
It has not yet been posted publicly, but it will be, and it is publicly available.
Okay.
Question then?
Yes.
So for purposes of this matter, are we accepting this, while it is a public document, are we accepting it as part of the record for what we're doing, since it was late filed? Or should there be a vote on that?
That is up to the commission. Commissioners wanted to see it, we passed it out, but that is up to you all as to whether you want to consider it.
Okay. Consider, okay,
Just for point of order, maybe we should hear the probable cause
yeah,
stipulation, or,
let's do
and
that.
then we'll
And then we can,
move on.
sounds good. The floor is yours, once more.
Thank you. As I said, this case involves the respondent, who is a former Florida State Senator, a lobbyist, and a former Senate employee. In this stipulation, the respondent admits that he corruptly misused his public position in terms of the lobbyist, which is in allegation 3. Allegations 1 and 2 would be dismissed. As you are aware, with former legislators, there are special rules, and I'd like to go through that process with you right now. If you reject the stipulation today, the case will immediately go to the Division of Administrative Hearings for a public hearing. That's essentially a non-jury trial. If you accept the stipulation today, the case goes to the Senate for their approval or rejection, or whether they will even take jurisdiction. If you find that there is PC and the case is forwarded to the Division of Administrative Hearings for a final hearing, if we prevail there, the case comes back to you and the complaint is still effective, you would make a recommendation or accept the recommendation of the ALJ, and the case would then be forwarded to the Senate for resolution there. If you do have the opportunity, if you disagree with the findings of fact, you may find that they are not based on substantial, competent evidence. If we don't prevail at DOA, at the Division of Administrative Hearings, the case is dismissed. Several years ago, the Senate appointed a special master who investigated the allegations of this case, and the former staffer's case was settled by the Senate. The investigation was sent to FDLE, who forwarded it to the state attorney's office, and the state attorney declined to prosecute. So what we have here today is a stipulation for a violation in hand. The parties agree that the process was fair by agreeing that certain facts are uncontested. In addition, they find that by agreeing to the stipulation, significant, substantial amount of resources would be saved. But more importantly than that, the victims would not be re-traumatized by having to relive their experiences again publicly. The stipulation empowers the Commission to move forward today with a violation that exposed corrupt intent on the part of respondents. Sustaining the stipulation now puts the matter or any questions to rest about the respondent's culpability. He admits culpability. I request that you accept the stipulation. Thank you.
Members, any questions? You're recognized.
Well, is anyone else going to speak at this point? I guess that's a question.
We will, yes, there will be an opportunity for the respondent to provide any comments if they wish to.
Before we, I have a question and a motion that I wanted to make, but I don't think this is the proper time.
Correct.
If we haven't heard from someone else.
Correct. Unless you had a question for Ms.
I do not.
Okay, all right. Any other members have a question?
I do. May I just clarify what you explained as the process? If we accept this pre-probable cause stipulation, it goes to the Senate with the fact pattern that was accepted in the stipulation, and they do not open any additional items? Or today is the last day it would be heard if we accept the stipulation?
If I may, through the chair, they can do their own investigation again. However, they probably would rely on what they already did.
Are there any other questions? Okay, thank you.
Thank you.
The respondent may wish to comment on the stipulation, and if you do, you can come on up. And for the record, could you state your name?
Yes. My name is Ryan Andrews, Vice Chair, members of the Commission, Ryan Andrews, on behalf of Jack LaValla. This complaint was filed first almost 4.5 years ago. It sat here for a while. It was investigated more recently. And the Commission's investigators did a thorough investigation. They interviewed several witnesses, including Mr. LaValla. Once the investigator's report was submitted and the advocate made her recommendation, a substantial amount of time was put into discussing the investigation, the evidence, including the evidence that Mr. LaValla could not provide to the Senate's, the special magistrate who was appointed on the case. There's a reason why we're here today on a proposed settlement, and that's because the evidence was clear on several points. One, the staffer who alleged that there were other women who were subjected to physical or verbal harassment were interviewed. And when they were interviewed, they denied it entirely. They wouldn't corroborate any of the staffer's allegations. There were other allegations by the staffer when she said that some of these events happened in a room full of people at the Governor's Club. Yet not one witness from the Governor's Club could be found to corroborate her allegations. In fact, there were witnesses who were found whose statements very clearly contradicted the staffer's allegations. The staffer also accused Senator Latvala of groping her in an elevator. While her story changed several times, I think we made clear in our response to the advocate's recommendation, she finally settled on a few-minute period, which unfortunately, for her allegations, Mr. Latvala was on 2 separate phone calls, so he couldn't have been on the elevator, this particular elevator in the Capitol. So we think that there was an ample reason for the advocate to stipulate to what was ultimately agreed to by Mr. Latvala. The advocate also agreed that it was likely that those allegations couldn't be proven by clear and convincing evidence. And again, this wasn't a perfunctory submission. There was substantial time put into discussing this with the advocate and going over specific parts of the record and the evidence, including what Mr. Latvala provided. I think that the advocate's stipulations should carry a lot of weight here today, and I'll tell you why. I would have first admit that probable cause probably couldn't be found on any of these allegations, but as some people on this panel know, and this is not a concession on probable cause, but sometimes you may be able to have probable cause on a case, but you know you can't win in court, so you don't file the charges. Happens all the time. Here, while their probable cause probably couldn't be proven, subject to the commission's vote, there certainly couldn't be a finding in front of an ALJ that comes back here with a finding of violations against Latvala on any of these charges. But Mr. Latvala acknowledged in the investigation to this commission's investigator that he may have used poor judgment in his relationship with a lobbyist. Both agree that there was nothing corrupt about it. There was no quid pro quo. There was no ask and no give for anything related to official business. That's why FDLE punted and said they weren't going to do anything, because they knew there was no evidence. But nonetheless, Mr. Latvala conceded that he may have used poor judgment, which is why he's entered into this stipulation before you today. This settlement agreement will allow these women who came forward to not have to relive what they have alleged and have stated under oath happened, but allows everybody to move on as well. Mr. Latvala, as we all know, is no longer in public service. And this settlement agreement sets a foundation for this commission and future conduct for members of the legislature and lobbyists to be on notice that relationships between members and lobbyists may not be appropriate. It's the type of stipulation that could lead to several cases in the future if this is truly the conduct that's not permitted, as has been stipulated, agreed to, and before the commission. It allows, it sets a foundation for the commission moving forward, which I think serves the public's interest, serves the interest of the people in this case, and which is why both sides have agreed and stipulated as such before the commission. Thank you for your time, and I would ask that this stipulation be approved. And if there's any questions, I'd be happy to answer them.
Members, do we have any questions? Okay. All right. Hearing no questions, you are recognized, sir.
I don't know who to ask this of, I guess the staff, the attorneys, or maybe the advocate, but what is the maximum penalty should this panel find probable cause for these events that he is in the complaint? What is the maximum punishment that can be imposed? Penalty, I guess penalty, not punishment.
Thank you. In terms of civil penalty?
If we go to a hearing and a judge finds that there's been a violation of the ethics laws, what would be the maximum punishment that could be imposed?
Through the chair. Up to $10,000 per allegation, public censure and reprimand, removal or suspension from office, which of course is not appropriate, and loss of a certain amount of money, which would not be involved in this. It would be loss of pay, which we would not have in this case. So to boil it down to what it would be is up to $10,000 per allegation. Public censure and reprimand. And I believe that's all.
Under 112.317, which lists the penalties for different classes of former and current public employees and lobbyists and former legislators, et cetera, it would be a public censure and reprimand, a civil penalty not to exceed $10,000 per violation, restitution of any pecuniary benefits received because of the violation committed, and that would be it.
Sir.
I have a motion that's going to be kind of convoluted. It may not make any sense to any of y'all, but it does to me, so I'm going to make it. I move that we reject the advocate's recommendation and that that's part of it, I'll keep going, and that we go into not a recess, but a stand at ease for a few moments, and that this commission recommend that a $10,000 fine and public reprimand and censure be imposed against the respondent, and that we take a brief, not recess, but just stand at ease to allow the respondent to consult with his attorney to see if he wishes to accept that by stipulation today. If not, we move into normal call.
Okay. So I see our executive director. Go ahead.
Thank you, Chair. Procedurally, at this point, at this juncture, the options are to adopt this stipulation as presented or reject the stipulation. If there is a rejection of the stipulation, we would move straight into a probable cause proceeding.
Well, would it be improper to allow the respondent the opportunity to consult with his lawyer for a brief time to see if he could enter into a stipulation according to what I have recommended, the maximum penalty?
Through the chair.
Yes, I was going to say, but we also don't have a second to that motion, but I would love to hear what you have to say, Steve.
Through the chair, as the executive director did say, the choices on this particular matter are to accept or reject the stipulation. There is no ability at this point to amend the stipulation or for the parties to propose a new stipulation for you to consider today. And the reason for that is there are certain notice requirements that go into this. The complainant, for example, through our rules, is allowed an opportunity to review the stipulation and then provide you a response. He's allowed a certain amount of time to do that. So because there's no time for that for today, you wouldn't be able to have a new stipulation presented before you today.
Okay, can I amend my motion then?
Hearing.
I move we reject the stipulation.
Okay.
Second.
All right, so it's been properly motioned and second. Do you have a question?
I do have some questions that are for clarification of what would happen, so I would know how to vote on this, if I may,
Yeah.
Chair. And I think that they would be directed to Councilor or our Executive Director. I failed to ask the complete question, I think, on the stipulation portion. I asked about fact patterns and things that would proceed to the Senate and what they would be allowed. But if we accept the stipulation, do allegations 1 and 2 go away and the Senate does not have the option of addressing them?
Through the chair, yes, sir, they go away. They're dismissed by the commission.
And I have a second question because I don't know where we stand on this given how long it took to take up. If we do not proceed today, is there an issue with statute of limitations in terms of time should the Senate not take it up in a timely manner?
You're recognized.
Thank you.
Yeah.
If I may, through the chair, I read the rules of the Senate. I spoke to General Counsel about that. They do not have any statute of limitation for this particular item. The House of Representatives does, and they sent you a letter back in March of this year regarding a 2-year statute of limitations.
Sir? Thank you very much for the follow-up, Chair. I guess I'm just as concerned with the respondents' rights. At what time does this case become stale for them? I understand that if we forward it, so the statute of limitations I'm concerned about is the original filing.
Again, if I may, through the chair, we don't know if they're going to accept jurisdiction of the case. I intend to talk to the general counsel this afternoon about it. I spoke to him yesterday, and that there had been no decision. They don't know what they'll do. They don't know if they will reinvestigate it, rely on the old investigation, or reject jurisdiction. We just don't know.
To the Executive Director of General Counsel, I guess, I understand that part, and I'm not concerned about that part, but at some point, is this going to run its course and nobody will have actionable time left? For example, my understanding is that if there's not an initial ruling, let's just say within 5 years, because that's what has been explained to me, and the Senate doesn't accept it, if a rejection today leaves no action, really.
Through the
Is
chair.
that what I understand correctly?
No, sir. No, sir. We have no time limits. However, we would want to quickly move this along for the victims' benefits.
Okay.
Everybody's
Right. Any other questions?
Well, if the motion passes, then I'm assuming we move right into a probable cause hearing today.
I was about to ask Steve that, so could you clarify if the motion is accepted and passed, what happens next?
Sure. So if the motion to reject the stipulation passes, you will immediately go into a probable cause hearing. The reason for that is this is a pre-probable cause stipulation. The parties have been noticed that if the stipulation does not pass, is not accepted, that we will then hold a probable cause hearing today.
Okay. Any, yes,
Just to clarify, so when the advocate was recommending that if we have to accept probable cause before it moves further to the Senate, is that what you're suggesting?
So just to clarify what those steps are, if the stipulation is rejected, the next thing is today you will hold a probable cause hearing. If you find no probable cause, then we issue a no probable cause order. You're familiar with that. If you find probable cause, then we issue a probable cause order. The matter is then ultimately referred to DOA. The parties will sometimes enter into more stipulation talks between the probable cause finding and the going to DOA. Once it goes to DOA, there will be a public hearing. There'll be a recommended order. You will have to vote on a final order at some point. And then once you have entered into a final order, then the matter will be referred to the Senate President.
okay. So we have a motion,
Chair,
sorry.
is that the same thing, though, that the advocate presented?
Yes.
Okay, thank you. Just clarifying.
So we have a motion.
Can I
Abs-
support Commissioner Carvajal for a second? I do think there was a step omitted in the description that was previously given with
Thank you.
respect to the probable cause finding that would be required pre-DOA, that you just heard articulated by the general counsel.
Thank you.
Is that
I think so.
consistent with what you heard or didn't hear?
Okay. We have a motion, we have a second. All in favor, say aye. Well, no, let me just make sure. We have a motion and a second to reject the pre-probable cause stipulation. All in favor of that motion, say aye.
Aye.
All opposed, say nay.
No.
Okay, roll call.
Yes.
No.
Yes.
Yes.
No.
So the stipulation, the rejection of the pre-probable cause stipulation is approved, and now we move into the posture of a probable cause determination. So the probable cause determination preliminary investigation, the respondent and the advocate are permitted to make brief statements in the nature of the oral argument to the commission based on the investigative report, the advocate recommendation, the complaint and staff recommendation, as well as any written statement submitted by the respondent. No testimony or other evidence will be accepted during the hearing. If probable cause is found today, the respondent will have the opportunity to request a full evidentiary hearing before an administrative law judge at the Division of Administrative Hearing, or enter into a settlement agreement. Each party will have 10 minutes. The commission advocate will present probable cause recommendation first. Then we will hear from the respondent. If the advocate reserves the time for rebuttal, rebuttal is allowed. Is either the respondent or complainant or their counsel in attendance? They are here. So, yes, sir.
If they're going to have a 20-minute hearing, you've been here 2 hours, maybe we're going to take a brief break for the commission so that they can get prepared.
Okay, that's fair. That's fair. So with that said, we're going to take a brief break. It's 10:30. We'll come back, say at 11, and then we'll get it going from there. That's too long?
That's too long.
We got to
So
take,
let's do, it's
so a 15-minute break. We'll be back at 10:45.
But we pee first.
Big shoulders, big shoulders. Great. My term is over.
I mean, or maybe he'll do it really fast if he doesn't. I'll just vote y'all. Tense. Sorry, I'm not gonna be the one. Sorry. I think if I hadn't been standing here, y'all would have just had it.
How do we set this up as quickly as possible to do this? 8. Sit 3 and stand 5? Yeah, let's sit 3 and stand 5. What do we need to take out of the way? Yep. Do we need to clear the desk? Do we need to clear the desk? The microphone's out. Richard, how much of this can you see? Can you see the stuff on the table?
I see a couple of the water bottles. That's it. That looks good.
Is that better? You can't
That's
see any of
awesome.
this?
That's good.
I know, I'm sorry.
Do you want me to move this little?
Less than ideal, yeah, we should move that. Set it down right, yeah. Remind me to move it back. tell the others.
I just want you to note that I know you wore your seersucker today. I took note during the meeting and said, tell your wife that I noticed.
I figured I needed to. Proper day though, you know, this weather.
How was Bare Naked Ladies? Being the proper weather.
Oh my God, it was probably one of, if not the best
Could it have been
concert.
the first time to ever mention the name of that just now? But anyway, go ahead. No one else, I know it, I know what it is. No one else knows what it
But
is.
it was such a great concert.
Yeah, what a great venue.
Bring coolers. We didn't know anything, but you could bring coolers, but we had people there, so. And we got
Oh, really?
Oh, yes. They are, it was just such a fun.
Is that your first time seeing him in concert?
No, I've seen it before, a couple of times before, but this time was the best just because biggest
advocate for the commission. This case involves a former Florida senator whose name is Senator Latvala, and it also involves a lobbyist who lobbied in the Senate. And it also involves a former Senate employee or a staffer. The complaint was filed over 4 years ago in the Senate by the former employee. And what she alleged, I will list out and the dates. In 2013, in the Senate office building, the former employee said that the respondent looked her up and down and made a growling sound when he was looking at her. In 2013 through 2014, the respondent made her feel uncomfortable more than 30 times by his various comments. In 2013 or 2014, during the legislative session at a local bar, the respondent made the comment to the former employee, "You have lost weight. You're looking really hot." In 2014 at the Governor's Club, according to the victim or the former employee, the respondent growled at her, looked her up and down, stared at her breasts, and again said, "You're looking really good." She responded by saying, "If you say that again to me, I will call you publicly obese, nasty, and dirty old man." In February 17, 2015, respondent sat next to her at the Governor's Club, where he rubbed his hand on her upper thigh on her left leg. The special master found that that allegation was not substantiated. On February 18, 2015, the next day, a former employee resigned from her position as a staffer. The former employee believed that the respondent, because he was a high public official, had the authority to take or direct others to take, recommend, or approve any personnel action against her. With respect to that authority, she reasonably believed that she should cooperate with the respondent and not report him. Therefore, for allegations 1, I recommend probable cause that the respondent accepted sexually oriented favors from the lobbyist, who, as you know, he admitted to having a 20-year affair with her. It was a consensual affair, but he accepted sexually oriented favors from a female staff member or lobbyist with the understanding that his official actions would be influenced. He could be influenced by the staffer cooperating, and she cooperated because she was afraid of actions he would take against her in her employment capacity. As to allegation 2, there is probable cause that respondent violated Section 112.313, subsection 4, by accepting a thing of value with the exercise of reasonable care. He should know or should have known that it was given to influence the action that he was expected to participate in his official capacity. In terms of the former employee, it was expected that he would treat her favorably and not take any personnel actions or recommend any personnel actions against him, or against her, excuse me. As to allegation 3, there's probable cause to believe that the respondent misused his official position by engaging in sexually romantic-oriented comments, behavior, and/or invitations to female staff and to the lobbyist. Again, he did agree that the lobbyist and he had a consensual 20-year affair. The respondent used his position, or because of his position, he was able to access the former employee and conduct this behavior. Therefore, he did use his position in that regard. I ask that you find probable cause on all 3 allegations. Thank you.
Question, Mr. Chair?
Yes, sir.
Thank you, Mr. Chair. Just a question. In recommendation number 1, it's actually just not, it's not clear. Who is it that you're claiming that he accepted sexually oriented favors from. It says female staff member, and it says then and/or a lobbyist. So, I mean,
Well,
who is it?
Thank you for the point, or the opportunity to clarify. He did accept official favors from the lobbyist, or sexual favors from the lobbyist. We could not find any quid pro quo for either allegations 1 or allegations 2 regarding the lobbyist. But for the female employee, she did tolerate some touching. She tolerated the comments that she thought were sexually harassing, and with the understanding that she'd keep her employment if she agreed to play along with these and not report them.
Follow up, Mr. Chair?
Yes.
Thank you, and I get all of that. I understand that, and in fact, there was a separate settlement as it relates to that individual, if I'm correct, that's the same one who had a settlement with the Senate.
Correct.
So, as it relates to this recommendation right here, so we should pull out the portion that says the female staff, because there was no, that's just not accurate, right? There were no sexually oriented favors. He may have said a lot of things, and he may have said things wrong, but that's just not correct, right?
If I may, through the chair, according to her, she allowed him to touch her inappropriately.
Any other questions?
I'm just kind of thinking to that, because I did read through the whole 100-plus pages of everything, and I know there were allegations and everything, but nothing got corroborated at all from the standpoint of what was in any of the investigation or anything of what we said as it related to the staff member. Correct?
If I may, through the chair, that would be in reference to the elevator incident. When they were on the elevator together, she alleges that he put his arm around her. He refutes that, and he has presented evidence to refute that. But that would be where she allowed him to touch her inappropriately.
Okay, and then, so then just to follow up then in terms of, you had made a comment, you had stated there that the staff member, because of, I believe the staff member is only involved in this allegation. Well, no, I guess you do allege it in 3, the staff member as well.
All 3.
Okay, so even though, and I know we were here before for the stipulated settlement because you have a difficult time, you will have a difficult time proving allegations 1 and 2. I mean, I think you have a difficult time proving all 3, but I certainly think 1 and 2 you have a difficult time. I agree with you on that. So, but in this one, just because she thought that he had control over her because he was a very powerful senator, doesn't mean that from an employment standpoint, he had any control over her whatsoever, nor was there any evidence. In fact, the evidence was to the contrary. She didn't work for him. She worked for somebody else. He didn't hire her. He couldn't fire her. And so from an employment law standpoint, because, I mean, that's really kind of where we're at, he really didn't have any influence over her employment. She just thought he did. So is that sufficient to at this point, find in favor of this allegation, probable cause?
If I may, through the chair, I believe that it is. You are absolutely correct. She was not supervised by the respondent. She did not work for him, but she believed that he was powerful enough and had the connections that he could affect her employment. I believe that is enough.
Yeah.
She felt like she had to continue to allow this to go on because of his position.
With all due respect,
Yes.
from an employment standpoint and legally, that's not sufficient. It doesn't, I mean, that case will be dismissed every day of the week from the EEOC, and I say that because that's the law I practice.
Through the chair, this case will rely on testimony from the respondent and testimony from the alleged victim, the employee. former employee. There is no corroborating evidence. Possibly, I can get in some Williams Rule evidence. I don't know about that, but I will certainly try.
Thank you, Mr. Chair. No more. Sir, you're recognized.
Thank you. And I'm asking this question less because of what I read in the ROI, but what the question that was just asked to you. Is this a typical employment setting, and was it not publicly noticed that the respondent in this case was going to be a future leader potentially in the chamber that he was representing? And it's possible that somebody could believe that he would have influence over her current or future position.
I think it's quite possible. She believed it. Whether it was accurate or not, she believed it.
Any other questions for the advocate? Thank you.
Thank you.
All right, the respondent's legal counsel? Or well, does the respondent want to? Okay, yeah, the respondent can come.
And that was going to be my, thank you, Mr. Chair. I don't think this is a signal on my efforts, but I think the respondent would like to speak directly to the commission as well. So I would ask if we could both speak, or if only one can speak, if he may be allowed to speak.
That's fine.
For both?
Yeah, both of you guys can.
Great, thank you.
Within the 10 minutes.
Within your 10 minutes.
Thank you.
Thank you very much, Mr. Chairman. I've been waiting 4.5 years for the opportunity to, in a public forum, to tell my side of this case. It's really ironic. I look up here this morning, and the special master from the Senate is staring down on me because he's a former justice in this, or a judge in this court. Your entire investigation here, or the complaint, is based on that special master's report. And I gave my life to the Senate, and I know the Senate rules pretty well. One of the rules in the Senate is when someone makes a complaint against a senator, they're supposed to be given the specifics of the complaint and given an opportunity to refute it. This whole process carried out, and the first I knew that there was an allegation of the sex with a lobbyist was on the day the special master's report was issued, on December the 20th of 1987. Never had an opportunity to present any kind of argument on that, any of the facts or whatever. Likewise, the story about the elevator kept changing. The first story on the elevator, it was in the morning. I got on the elevator and I said a raucous, "Good morning." Well, come to find out after, some of that was disproved, and this is, by the way, the elevator that has swipe cards. You have to swipe a card to be on it. They could never put me and her in the elevator at the same time. Finally, after a long process, on the day the report was issued, they came up with the date that groping supposedly happened. Between 3:21 and 3:30 on a certain date. I didn't know about that until the day the report came out. Well, it was a pretty traumatic period. A few days later, all of a sudden it dawned on me, well, my cell phone has, minute-to-minute log. If I call them, I can get the log of my cell phone calls. So I got the log, and of that 9-minute segment, 6 minutes are on my log as being on a cell phone call, 2 different cell phone calls. That elevator, as anybody in the Senate knows, doesn't carry a cell phone call. It's the one in the building, and I guess it's got lead around it or whatever. But I refuted that. The staff members' allegations. The allegation that she saw me with my hand inside the blouse of a lobbyist in the majority office upon the special master interviewing the other 3 people that were in the office at that time. All 3 of them said under oath that did not happen. She alleged that I did something at the Governor's Club. Investigation, whatever, not only could they not find anybody to refute it, but in talking to wait staff and other patrons that were there at the same time,
there was no corroboration at all. And, you know, this was in the Me Too period. This was a, this was a tough time. Biggest mistake I made was not standing and fighting right then. You know, I knew this complaint was filed. It petered along for 4.5 years. And then all of a sudden it reaches up this year after sort of, you know, I've moved on to a lot of other things. But my not fighting stops today. I didn't do what she accused me of doing. What I did was I had sex with a lobbyist. Okay, I admitted that I had sex with a lobbyist. Well, ironically, the rules chairman who supervised this so-called process of this investigation married a lobbyist shortly after this, and had obviously been with that lobbyist before they were married, and he was still a lobbyist. No complaint got filed about that, but obviously the same set of facts. You know, I'm not justifying anything because, quote, everybody does it, but I think it's important to put things in the context in which they happen. It's important to look at, are you now going to establish a precedent that whenever somebody's different in the legislative process, when they won't do what their leader tells them to do, then all of a sudden they're going to be subject to a complaint because somebody knew they slept with a lobbyist. My first 10 years, I was single for 10 years. Most of that happened when I was single or when I was in the Senate the first time. And that particular, you know, and I wasn't by myself, let's just leave it at that. I think that I've always had great respect for this commission. I've always thought that you did thorough and complete work, but what we're doing here today is basically the equivalent of a guilty verdict to allegations that the FDLE looked at, that your predecessor looked at, Mr. Meggs, and found that there wasn't anything illegal. The lobbyist testified under oath to the special master that there was no quid pro quo. She quoted saying the same thing to the Miami Herald. There was no quid pro quo. This was social relationships. And again, if you're going to start making that the basis for complaints of having sex with lobbyists, you're going to be a very busy commission. I did the wrong thing. I agreed to that stipulation despite my wife's objections, who wanted me to fight this out, because I didn't want to go to an administrative law judge and the process in 6 or 8 months, and the legal fees and the time and the sacrifice on my sleep life and so forth to keep that going. I just wanted it over with. Kind of like the day I resigned from the Senate. I wanted it over with. But that, as I look back now, was a mistake because people consider that an admission of guilt. I didn't do what's alleged here now, and you know I'm gonna leave it at that. And I appreciate your consideration thoughtfully on this matter. Thank you very much.
Thank you. There's not a rule that says you can't have a relationship with a lobbyist. It says you can't do so corruptly. You've got both people involved here through the report of investigation and what's been otherwise reported. Both have said that nothing happened. There was no quid pro quo of anything. Nothing related to official business. So is the commission, if they would find probable cause, is the expectation that one of the two would now change their testimony, despite giving multiple statements under oath, including the lobbyist? Several statements under oath saying never asked for anything, nothing was ever given to her for that relationship. Does the commission expect her to say, actually, I perjured myself a couple of times before, actually, we did exchange something? What does the commission expect to change if they're going to find probable cause on that? Waste time, resources, and money, and put this person through something that she has already said never happened? Next takes me back to the staffer. There was questions about her mind and what she was thinking and whether she thought that somebody could have power over her who she didn't work for. Frankly, if we're really going to get into what she thought, let's really get into it. She accuses Mr. Latvala of doing stuff to her since 2013. Yet in 2017, she begged him to stay at his house in Maine. She begged him to fundraise for him. Who would do that? If everything that she said is true, who would do that? She wasn't required to go do that. She had to ask for time off from work to do it. Bring him food. Send him emojis. We're not talking about middle school people. We're talking about adults. What kind of an adult would send an emoji to another adult who's been sexually harassing them for several years? If anybody doesn't know what emojis is, I can go into that. But this is a very simple concept. We're not just talking about she said this, he said that. We're talking about, we have objective evidence, reasons that you should not find probable cause as it relates to the staffer's allegations or the lobbyist. But more importantly, we have actual evidence by other people who said what the staffer said wasn't true, that about them, about the staffer, and about Mr. Latvala. What more can you possibly hope to find? They interviewed dozens and dozens of witnesses. People are going to change their mind under oath? And again, in closing, and I apologize, this is the last thing I'll say. How can we really be curious about who she thought could affect her job when begs to stay at someone's house who she claims has been serially harassing her when she's under no obligation to do so and for no benefit of her own? And with that, I would ask that you all vote to reject the probable cause findings. Thank you for your time.
All right.
Any questions, I guess?
Any commissioners? Yes, sir.
I read through all of this material, and there's a lot there. How do you explain the $900,000 settlement that the staffer paid with our state?
Easily. First of all, Mr. Meggs, I never got the chance to deal with you as an attorney, so it's an honor to be able to stand in front of you today. But I will say...
Don't get too excited.
No, I know, I'm not that excited. It's just out of respect. I'll say, first of all, they didn't ask Mr. Latvala to consent to the settlement. But more importantly, it was her own boss that was pushing for the settlement. Her boss, who is now the president of the Senate, who's going to be a witness in this case. Well, I have no idea why they gave her the money. I can't say. Those people aren't here, but that doesn't mean anything. And I'll use an even better example for you. I have had tens of millions of dollars of settlements against the state. Every single one of them, I'm always of the belief that I won, even though we have both agreed and stipulated that this is no admission that whoever the state agency is denies any wrongdoing specifically and generally, and that it was solely out of convenience and out of the best interest for the state. And usually when we're talking about that, we're simply talking about money, not because we're worried about allegations coming out. This would be the first time that a body like this would consider the number of a settlement when the settlement agreements specifically say that you can't rely on them for the purposes of fact or admissions of the allegations. If they had gone to a trial and a jury had found the Senate liable, or had found that she had actually been harassed or had been subjected to these things, it would be a different story, but we're not there. And I think that's a very important distinction, Commissioner Meggs.
Any other questions from commissioners? Okay.
Thank you for your time.
This is the advocate. I think you have a few minutes. No, she used all her time.
No, thank you. I'll waive it. If I have time, I'll waive it.
All right. So now we're in the discussion. Commissioners, anyone has a discussion or questions?
I move that we find no probable cause.
Is there a second? Is it on all three or just
on all three.
Okay.
Make another motion if that's not seconded.
All right.
Motion dies for lack of a second.
Yeah, nice.
I move that we accept the advocate's recommendation of finding probable cause on all three allegations.
Second.
All right. Is there any discussions on the motion? All right.
Thank you, Mr. Chair. Well, I mean, once again, we're back where we started in the beginning, and I have to say, I read everything. In fact, it was fascinating to read everything. But Mr. Andrews is correct. There was no corroborating evidence to so much of what was alleged. Now, I agree, it does not look very good for Senator Latvala and how he handled things. But I think that's why he was in here prior to this for the stipulated settlement as to allegation number 3. But as it relates to the staff, the employee, the law is actually pretty clear on it. Just because she thought it doesn't make it actionable. I mean, just because I think that, this telephone is mine doesn't make it mine. It's still Senator Grant's. I mean, that's it. In employment, she doesn't have really. She was lucky. She got $900,000. That was wonderful. I got to tell you. I mean, but it's a settlement. It's a settlement because both sides look at it and they say, what makes sense here from a business standpoint? What are we going to do? What are we going to do from a public relations standpoint? We have a high-profile senator who is alleged to have done this, so let's settle this and get this over with. It's too bad because we had an opportunity today to get this over with and finally finish it after all of these years with the stipulated settlement. But that doesn't mean anything. That doesn't prove guilt, nor should it be used as an indicia of guilt just because it was settled and it was, in fact, as Mr. Andrews said, it was settled without Mr. Latvala's knowledge or agreement. I believe not knowledge. Maybe he did have a knowledge at the end, but he certainly didn't have an agreement to it. So here we are. We're going to just then shift this over to the ALJ and say, okay, now it's your turn to go and relitigate this when the investigation itself shows that these allegations do not have any clear and convincing evidence to prove. I don't know why we're here. We waste our time with so much of this stuff. And this is not about Senator Latvala. It's the process. Why, just because somebody makes an allegation, do we then shift it on down and say, okay, probable cause? Evidence isn't there. There's 100 and some odd pages of it, and just because the special master made some findings doesn't mean we should accept them. I don't find probable cause as to any of this. There was never, appeared to me, a quid pro quo. There were some poor statements made, perhaps by Senator Latvala, but they don't rise to the level of probable cause to prove these allegations.
Sir?
I would ask y'all to just indulge me just for a second to try to make a point. It'd take me a minute to get to the point. Back in my earlier life, I was a deputy sheriff, and I was working narcotics. This was back when the earth was beginning to cool, and I had an informant. We called him the Bird, and he was a pretty weird guy. And he was able to make a heroin buy in Tallahassee. Heroin was unheard of in those days. Matter of fact, when we took the buy that he made from the defendants to the lab here at FDLE, they weren't real sure how to do it, and there was much excitement across the state because I believe it was the first heroin that had ever been brought to their lab. Based on, and long story short, based on getting there, after the buy was made, it was a confidential source. I could not use the Bird, my witness, because he was incompetent. But I could take his information under the law and get a search warrant to go search the house for remaining and look for other heroin and other drugs. It was kind of interesting when we went to the house with the search warrant. that I had been in a lot of drug houses, serving search warrants, never went in one that was this clean. It was obvious that someone had tipped the defendants that we were coming with a search warrant. The place was immaculate. We were able to find a couple of marijuana seeds in a sofa. And we looked at that, and now we realized that these were heroin dealers because of our buy, but all we had was marijuana seeds. I may be wrong in my thought process about that, but I went to the state attorney as a deputy sheriff, Mr. Hopkins, and I told him this story. What we have here, Mr. Hopkins, is some bad people, but all the evidence we have is marijuana seed, and I want to see them prosecuted because they're bad people. And he filed a case for us. And we were able to do interesting things after that. I will not go further with the explanation about what happened. But the heroin sellers wanted to get out of trouble as quick as they possibly could, and they became kind of invaluable and got to a higher source. Long story short, and I can't remember all the details of it now, it's been so long. But because of our diligence of going and prosecuting the case on what we had. Now, we have allegations in the report about 56 women or 6 women coming forward and a bunch of people being interviewed. I've had cases where there's been a shooting with 200 people present and no one saw anything. So that's no surprise to a prosecutor, and it will be no surprise to our advocate when she gets to the hearing if this passes. So I would urge this commission to vote because it's the right thing to do, to find probable cause and get this matter litigated out in a courtroom where rules of evidence are followed and justice can be done. It is well known in our society today that most sexual assaults are not even reported because of the damage that it does to the victim in those cases. And so we have some folks who have been sexually abused, sexually harassed, that have come forward, and their testimony will be useful and valuable. And I think we can get to a just result if we send this over to DOA for our very adequate, well-trained, highly trained, former assistant state attorney takes the case over there. So I'd urge you all to vote to find probable cause on this matter. Thank you.
All right. Commissioners?
I'll speak up then. Okay. Thank you for the recognition, Chair. And to be honest, I don't know how to rule because neither is exactly where I want to stand, but I do want to mention a few things should this be my last day on the dais, because of term limits, by the way. Not because I think something's going to happen. Just to clarify a few items, even if I did support this, while the court of public opinion is clearly always against the respondent to some degree, this is not final. The probable cause is really just the next step in the investigation. If the argument that the respondent is making is that the information is not valid and accurate, then the next process will allow that to play itself out. I think the things that are bothering me more have to do with a little bit of tone deafness and the difficulty that will never play itself out through DOA or through evidence. And one is the power relationships that people in positions, often in an office supervisor, but more importantly in a legislative process, every elected official has over everybody else that's in this process, is going to be difficult to explain. It makes me angry that a woman and a man relationship is always difficult to show. It's always a he, she. That's just the world we live in. But with all respect to Commissioner Waldman, the legislature is above the court in some cases in employment law, so this will play out slightly differently than just a typical employment case. And it should, in part because, just as the respondent's attorney noted, positions and folks that have held elected office have an aura around them. The doughy-eyed that he expressed over Commissioner Meggs, well-deserved to some degree, kind of shows that the chamber and the positions do matter. It is something that will never be able to be proven, but it does matter in this process. The fact that I probably can predict who's the leadership in the House and the Senate now for the next few years is not something that normally happens in a workforce, but it does happen in this legislative process. It'll be difficult to prove that those played into any of this. I unfortunately do know a little bit more about this case, having lived in Tallahassee and read about it before I got onto this case, so nothing since, but there's no good solution in any of these cases ever. And if I support this, it's because you get a chance to prove it out, but I just wanted to point out that this is not your typical he said, she said, because of the context. Just like we're in a court right now, that's different than just being on the street or in a typical office. So there's no easy answers on this one. But I wanted to really emphasize the power balance issues that are unique in this situation. Thank you, Chair.
All right. You're up, if you have something you want to say.
I have so much to say that it's really just hard to focus on those things that are most relevant to the motion and the probable cause issues. And so with those, I'll respond partly to some of the comments of other commissioners. And one that did kind of strike a nerve, I don't think in my terms, and I don't think anything else was really intended by Commissioner Waldman, but I am sensitive that the almost $1 million payment from the Florida Senate was not made because the staffer was lucky. That came on the heels of she did not get lucky. She had to bring a federal EEOC complaint, and there was some merit to it which justified that payment being made. But I still can look at that outside of the issues that are right directly in front of us and what occurred that we know from the report of investigation. And what we know is, regardless of the impact on the lobbyist and whether that was consensual, regardless of the impact or the perception of the employee, there is a perception to me that there's been an egregious violation of the public trust for which these ethics laws exist. And for that reason, I feel that this is a case that should be further litigated in front of DOA. Corroborating evidence is not required. A single person's testimony is evidence, and it will be the passionate speech by Senator Latvala, and it will be the testimony of those other witnesses, even if there is only one. They don't have to be corroborated to be sufficient evidence. Whether they reach the standard of clear and convincing evidence is one the judge will determine, and I will respect that judge's findings after having had the opportunity to hear in more detail even that which we can hear today, because that judge will have the opportunity to hear it more directly. But I think that it is incumbent upon this commission to put it in front of the ALJ and to find probable cause on all three of these allegations.
Just, Mr. Chair, just a point of order. And I don't recall there being an EEOC complaint. You said that there was, and perhaps somebody can let us know, because I don't recall seeing it, and if I did, I missed it. But because the EEOC complaint, then they actually come out with a determination. There's certain notices of right to sue. There are things that go on. Was there?
So, yes, you're recognized, Executive Director.
Yes, the investigator has indicated that there was in fact one.
And what was the determination by the EEOC?
Through the chair?
Yeah.
It was settled, so it never came to fruition. It settled it before the case came up.
Okay. We've had discussion. We have a motion on the table to accept all three probable cause. I guess we, all in favor say aye. Aye. All in favor say nay.
No.
Yeah.
I will side with ayes in favor.
Okay, let's just do it on the record. Can we do a roll call?
Yes.
No.
Yes.
No.
Motion passes. All right. So, that's it. You want to take a quick break? So we'll take a quick break. And we'll be back in 5 minutes, so 11:30.
I will vacate your spot, sir. Steal my purple. You want my purple?
I don't want your purple mouth.
It's how I keep from losing it. I had a black and gray one.
Thank you.
It kept disappearing. So,
This is not the one that's gonna take me down.
wait.
Will the parties please identify themselves for the record? Melody Hadley. Is anyone here for the respondent? No one else is present. All right. It's a proposed probable cause stipulation between all parties, and Ms. Hadley will present that, and we'll have questions from members, and then see if there's a motion to adopt or reject. Ms. Hadley, you're recognized.
Respondent served as a member or chair of the Board of Supervisors of the Coquina Water Control District. The commission found probable cause to believe that she violated sections 112.3136, 112.3133, and 112.3137 of the Florida statutes. Prior to the commission finding probable cause, the respondent resigned from the board. After the probable cause order was issued, respondent retained private counsel. At the time, respondent was also confronting medical issues. Between the pandemic and the private counsel's request for more time to provide a note, doctor's note similar to Exhibit A, which is attached to the stipulation, time passed. On October 10th, 2021, respondent was no longer represented by counsel. Within a couple of months of me being able to communicate directly with her and with the help of her husband, she was able to provide the doctor's note that, again, is attached as Exhibit A. I believe in my original recommendation to find probable cause on the matters before you. I also believe that it's in the best interest of the public to resolve the case as presented in the stipulation based on the circumstances. In the stipulation, respondent admits that she violated the aforementioned statutes and agrees to the entry of a final order recommending a civil penalty of $1,500 with public censure and reprimand. I respectfully ask for the commission's approval of the joint stipulation.
All right, there's no one here for the respondent. Are there any questions of the advocate from members of the commission? None appearing. Is there a motion from a member of the commission? Senator Gates?
Thank you, Mr. Chairman. I move that the commission accept the staff's recommendation and enter into the joint stipulation.
Is there a second?
Second.
Commissioner Carbajal?
Yes, sir.
Commissioner Wallman?
Thank you, Mr. Chair. I just want to make it known that it's about 20 to 12. This will be the first yes vote that I've given since 8:30 when I said I was here.
I will withdraw my motion. You're agreeing with it. For the record, that would be for 3 meetings now, so. You're growing as a person.
Thank you. Thank you.
Commissioner Carbajal, do you have a question? Or
No,
just
sir. I was just emphasizing that that was a yes vote.
Okay. Commissioner Gosine?
How did you come about the allocation for allegation 2 and 3? Why is it not uniform across all 4?
Because I find that a 6 is more egregious. A 6 violation, a misuse violation. So 1 and 4 are the misuse violations. And so in just my discussions with Mrs. Miles, it just ended up being in our negotiations how those amounts played out. But I wouldn't agree to do any lower on the 6 violations, which is allegation 1 and allegation 4, the misuse violations.
Further discussion or questions? All right, I'll call for the question. All in favor, say aye.
Aye.
Opposed, like sign. Show it adopted. Thank you, Ms. Hadley. All right, that takes us to the next item, which is Omar Hardy, 20-165, and consolidated with 20-184. Ms. Hadley, you're here for, as the advocate. Is there anyone here for the respondent? None appearing. Ms. Hadley, you're recognized.
Respondent served as a member of the Lake Worth Beach City Commission and as a candidate for the Florida House of Representatives at this time of the filing of his Form 6. The commission found probable cause to believe that he violated Article 2, Section 8 Florida Constitution and Section 112.3144 Florida statutes by filing an inaccurate 2019 CE Form 6. Through settlement discussions, the parties have come to an agreement In addition, the respondent has filed an amended Form 6, or he has emailed an amended Form 6. In the stipulation, respondent admits he violated the aforementioned Code of Ethics, and he acknowledged that he failed to list $2,047.50 in income, which he has now corrected, and agrees to the entry of a final order recommending a civil penalty of $1,000 with public censure and reprimand. I respectfully ask for the Commission's approval of the joint stipulation.
All right, any questions of the advocate? Do I hear a motion?
I'd move the advocate's recommendation for the joint stipulation as presented.
Commissioner Carvajal, is there a second? Second. Commissioner Meggs, is there discussion? All in favor, say aye. Aye. Opposed, like sign. Show it adopted. Thank you, Ms. Hadley. All right, that takes us now to financial disclosure appeals. The first two items are items where the appellant has requested a hearing, and that is Andre Perez, FD 19-086, and Melinda Ortega, FD 20-030, are either present today. Okay? All right. Then, Shuhal, you're recognized to take care of these matters.
Thank you, Chair. Good morning, Commissioners. Sohail Chopra, attorney for the Commission. This matter is Financial Disclosure Appeal 19-086, Andre M. Perez. Commissioners, the appellant serves as a member of the Board of Medicine for the Florida Department of Health. The appellant was required to file a CE Form 1 for the year 2018 by July 1st, 2019. However, he filed his form on January 12th, 2022. A blank form and a notice of delinquency was sent to the appellant. It is pertinent to note, Commissioners, while the USPS records indicated that the mailing was delivered, the identity of the recipient could not be confirmed from the signature. That's page 29 of the record before you. When upon the expiration of the applicable filing deadline, the appellant did not in fact file the form, he incurred the maximum fine of $1,500. In 2021, the appellant spoke to the Commission staff over the phone and stated that he had been living and traveling between the US and Spain and filed an appeal based on lack of notice. Considering the appellant's basis for appealing the fine is that he did not timely receive the notification of the form and also of the appeal notice, there may be a justification for unusual circumstances. Appellant communicated with us via email. Pages 10 and 12 of the record state that. Commissioners, there's no evidence to conclusively refute the claim of the appellant here. On the contrary, the appellant's detailed immigration and emigration records, visa stamps to and from Madrid, Spain, totaling to about 14 documented entry and exit post visa stamps during the relevant time period of 2019 and 2020, show that the appellant did not in fact receive the mailings. The appellant's absence from the country during those two periods does constitute unusual circumstances and, of course, in your fine sense of judgment, may justify waiving the fine. Page 20 to 27 are the detailed visa records before you. The appellant did request a hearing, but made the staff aware this week, earlier this week, that he was visiting the Dominican Republic for business, and that's why he could not be here in person. I'm happy to answer any other questions you might have.
Are there any questions? You will hear a motion. Commissioner.
For a motion to accept the staff's recommendation to waive the $1,500 and.
Is there a second?
Second.
Is there discussion? Commissioner Meggs. Discussion? All in favor say aye.
Aye.
Opposed, like sign. Thank you. All right, take up the next matter.
Commissioners, the next matter is also a financial disclosure appeal, number 20030, Melida Ortega. The appellant served as an assistant public defender for the 9th Judicial Circuit in Kissimmee, was required to file a Form 1 for the year 2019. A blank form was sent to the appellant's courthouse address on May 19, 2020. The notice of delinquency was sent on July 31st to the same courthouse address. It is worth mentioning, Commissioners, that while the USPS records indicate that the mailing was delivered, it is almost apparent from the record that the recipient was not the appellant. That's page 32 of the record before you, Commissioners. On July 30th, 2020, a day before the notice was actually delivered to the courthouse address, Ms. Ortega had been laid off from her position. The maximum fine was incurred, and the appellant did timely file an appeal based on lack of notice. The appellant in her appeal, Commissioner, states that she had not received any of the notices because she was made to work from home from May through July 2020, which is the relevant period during which the notices were sent. And she was laid off from the position a day before the notice of delinquency was sent by the Commission. It is evident that the appellant did, in fact, never receive the disclosure notices, and there is no evidence to the contrary. Based on these facts, the staff recommends that there may be unusual circumstances, which again, in your fine sense of judgment, may justify waiving the fine. The appellant did request this hearing, but made the staff aware ahead of time that she's taking court-ordered depositions in Orlando. I'm happy to answer any of the questions you might have.
Are there questions of members of the commission?
Quick question, Mr. Chair.
Yes.
Thank you, Mr. Chairman. How did it happen that we were sending notices to the courthouse instead of to the individual's home address?
Commissioner Gates, through the chair, I believe there's a registration process where everybody registers a particular address. And for instance, my own address for getting the notices at this moment is the commission's address. So it's the employer that in certain circumstances could get those mailings, but that's my limited information.
Mr. Chairman? So is it likely then that this individual listed the courthouse as her address for purposes of receiving correspondence from the commission? Is that what you're saying?
I would not be able to confirm that statement as to that. I would defer to the executive director on that.
Through the chair, as a part of compiling the list, and Ms. Holmes can confirm this, the coordinator for a particular agency provides us with the name and address information of all the filers for their agency. And so in some agencies, they will provide the mailing address as the office, particularly if it is where you have assistant state attorneys and assistant public defenders and the like, whose addresses might ultimately be able to be confidential. Sometimes they do have their things sent to the office instead of their homes. I can't say for sure that that was the case in this case, but it's always an option.
No. Thank you very much, Mr. Chairman. I have a motion if you're prepared to accept.
You're recognized.
Thank you, Mr. Chairman. I move that the staff's recommendation to rescind this fine be adopted.
Is there a second?
Second.
Is there discussion? All in favor, say aye.
Aye.
All opposed, like sign. Show it adopted.
Thank you.
We now have four others, 20-029 Schwartz, 20-31 Lane, 20-39 Gonzalez, and 20-40 Strauss. There is no hearing requested on those. Does any member of the commission want to pull any of those out to talk about individually, or is there a motion that we adopt the staff recommendation?
Mr. Chairman, to put the matter before you, I move that all four of these cases be disposed of by adopting the staff's recommendation in bond.
Second.
There is a second. Is there discussion? All in favor, say aye.
Aye.
Opposed, like sign. All right. That takes us then to item 8, consideration of second order on request for extension. One is Cheston Nathaniel Goodman and Austin Bollett. There are 2 requests for extensions to file. Both of these pertain to members serving in the military. They're self-explanatory from the meeting materials. If there are no questions, if there are questions, I'll ask Gray to respond. But if there are no questions, I'm open to a motion on these. Commissioner Gates.
Thank you, Mr. Chairman. I move that staff's recommendation to rescind the fines in both of the cases before us be approved. I'm sorry, that the extensions be granted in both of the cases before us.
Second.
Discussion, questions? Commissioner Wellman.
Thank you, Mr. Chair. Just like to thank them for their service in the military.
Thank you, so noted. All in favor, say aye.
Aye.
Opposed, like sign. Thank you, show it done. Our next item is commission consideration of the 2023 legislative recommendations. And I'm going to call on our executive director to kind of give us a brief overview. We're running late on our executive session, and we will go into greater depth on this at our next meeting in August. But Carrie, you're recognized to briefly talk about the recommendations.
Thank you, Chair. I will be brief, as I know we are running long and there are a number of people awaiting to be heard during the closed session. But the Chair asked for me to go through these very briefly, and I will, because we are very early in consideration of these, and then hopefully in September, you all can have some additional discussion and consensus on what we want to do. With the conflict of interest recommendation, that's been one that you've put forth for a number of years, and as you all were here last year for consideration of that, wanted to let you know that there was nothing in 2022 session that I'm aware of that related to that recommendation, but there was in 2021. So we have had traction on that in the past, and so that may be worthy of your consideration for this year. With the voting conflicts law, where you sought to make consistent the voting conflict requirements for state and local elected and appointed. There was legislation in 2022 that picked up on some of this recommendation. It picked up on it related to the local elected and appointed, but we did not have any traction with the state level voting conflict changes. So again, they've heard you, and there has been some legislation there. As you recall, there was quite a bit of activity surrounding the enhanced financial disclosure, where you recommended that municipal elected officials such as city commissioners and mayors would file Form 6. That one had legs this year. It had legs in terms of a straight requirement that was not conditioned on revenue to the municipality nor population. We thought we were in really good stead there, and ultimately it died in the House. It was amended substantially in the Senate, and we had some passage in the Senate with some other language. It has been conveyed to me by Representative Roach that he would be interested in carrying that again in the House in 2023 session, if it is something that we recommend. Obviously, we'll be dealing a lot with financial disclosure during the next session, and so that one is likely worthy for consideration as well. Dismissal of complaints alleging de minimis financial disclosure violations. I don't recall any legislation picking up this recommendation. Dismissal for de minimis financial disclosure violations is not currently allowed under the statute, but you do always have the ability to dismiss a complaint for any reason, finding that the public interest not be served by further proceedings. So as you consider whether you'd want to move forward with that in the coming year, you'd want to keep that in mind. With dismissal of lobbying firm audit matters, as you know, the commission cannot so-called run these complaints, and what you recommended here would be that the legislature pass legislation that would allow you that flexibility in these matters. They did pick up on that recommendation this year in a bill, HB 7067, that contained a number of things in it. That bill did not pass. It died on second reading in the House. That bill also contained some pretty helpful glitch language relating to the electronic registration and compensation reporting system for executive branch lobbyists. That was helpful. So moving forward with that in this next year would be definitely worthy of consideration. Penalties, increasing civil penalties, has been something you have long been seeking that we have not yet been able to get any traction on. The same The same could be said for 2022. There was no legislation filed that I'm aware of seeking to increase those penalties. With the whistleblower-like protection for ethics complaints, this was the first time, I believe, we were recommending this, where you were seeking enactment of provisions similar to the Whistleblowers Act for folks who file ethics complaints to avoid the threat of adverse employment actions. No legislation was filed related to that, but when this comes up again and you consider this, Steve has done a lot of research with regard to whistleblower, and he's our resident expert on that, so he'll be very helpful if you have questions there. The ethics training item was essentially a glitch item to bring in the CRA board members into the exemption from filing or from being required to take the training if you're elected after March. We think that was just an oversight or a glitch, and so you recommended that as well. There were the representation before your own board and the gift and expenditure and compensation items that you took a stance of opposing last year, and we can talk about that when we meet in September if you wish to continue to put those with your recommendations, or wish to just let me know that you wish to oppose them if I see them come up. Significantly, electronic filing, we will need something that addresses the launch date for Form 1s. The implementing bill that made the changes and the reversions that we're also familiar with changed the launch date for Form 1 to 2024, but the provisions in the implementing bill expire January 1 of 2023. And so if we don't have legislation, we'll be in the awkward position of everything reverting to the previous language, and we will people will be required to file electronically their Form 1s, which we will not have a Form 1 electronic system. I'm continuing conversations downtown and with the IT team about the things we've learned from our launch and our pause this year, how we can improve the user interface, how we can make the system more friendly to users and look and feel the way people would like it to feel, where they will be comfortable with it. And I will be having ongoing conversations with them and report back to you what support it is we might need for those actions. And with that, I turn it back over to you, Chair.
All right, thank you for that report, and we have a lot to do during the next session. We have circulated the 2023 meeting schedule that applies for whoever will be here. I think we're going to have a lot of changes next year. I think Commissioner Meggs and Commissioner Wallman and I go off in June, and
We just got appointed for another 2 years.
yeah,
We're here to 24.
well, maybe it's 24. Well, yeah, I guess it is.
Commissioner
Okay.
Akers just got reappointed.
Yeah, that's true. All right, anyway, for whoever's here, the meeting schedule is before you. Do you have any questions? I would suggest you do as I have done and go through your calendar and put those down so we can make sure we have a quorum. Reports, I only have one item in the chairman's report. Steve has been our general counsel now for, I think, 4 months, 5 months, something like that. And I have told him personally, and I want to say publicly, Steve, I think you're doing an excellent job. I know it's a hard job, and you put in long hours, and you have provided us with good work product, and I just want to say a public thank you.
Thank you, Mr. Chairman.
And with that, I'll turn it over to our executive director.
Okay, I do have a few things I wanted to let you know, because we have all survived what was the most interesting financial disclosure season I've ever been a part of this year. That currently the compliance rate for Form 6 filers who are not judges, we have 1,384 total filers. We had 1,157 timely filers. Currently, there are 227 Form 6 filers who have not yet filed. That's a compliance rate of 83.6%. That will go up We are moving towards that September 1 due date. We have postcard reminders that will go out. We will also have what we refer to in our office as Phone Fun Day, where we all take a break from our ordinary work and we burn up the phone lines and the email contacting anybody who has not yet filed.
Well, Madam Executive Director, I have a way that you can shortcut that.
How's that?
Just have people make the phone calls, just say, Willie makes us call. Everybody else sit up real straight and they'll do exactly what you say.
We'll take that under.
We're all still scared as hell of it.
That's not a bad idea. He is local, so we could bring him in. We could bring him in.
You don't even need him in, just say, Willie makes us calling.
He's on his way.
He's on his way to your house.
Your warrant is expired. They call me every day.
Well, we're quickly becoming those people, I think. For active and senior judges, they have a 96% compliance rate. Of course, their deadline is July 1, and we don't have any authority over their forms, but we do act as the repository. And for Form 1 state filers who file with the commission, we have 13,048 total filers. There were 11,694 timely filers so far, with a compliance rate of 89.6%. Ultimately, we do land in the 99% compliance land by the time we get through to September. So that I do expect these numbers to go up, but that's just a snapshot of where we are now. A couple of staff items to report. I want to welcome Kathy Hayward. She's our newest attorney on staff. She's very experienced in admin law, and she has already been involved in a number of legal matters at the office. She started near the end of June, so it's not been that long since we've had her, but we're really glad to have her with us, and we expect her to make great contributions to the work of this commission. Also, want to welcome John Cismaria as a new investigator. John is retired from the state attorney's office in Brevard County as an investigator there. And he also joined late in June, and I've already signed an investigative report that he wrote. We're very excited to have him with us. And with happiness sometimes goes sadness. We are saying goodbye to our summer legal intern, Gianni Croce. His internship is coming to a close. He's the first legal intern that we've had, and he did a great job researching various issues and drafting documents under the direction of our general counsel and in tandem with our other wonderful legal staff. And we just, please join me in wishing him well in his continued. Thank you. He did so well. We're hoping to have another one here in a few short weeks. Also sad to tell you that Suhail Chabra has accepted an offer from the Division of Emergency Management and will be leaving our staff within the next few weeks. We are sorry to see him go. He was quick to learn, and we'll be filling that position soon. And as I told him, this is only goodbye for now. People always come back. You never know.
Especially from emergency management.
It won't be long. And
Couple of hurricanes, you'll be back.
That is the truth. And last but not least, I have a few things I want to say about Bob Malone, our senior investigator. This is Bob's very last commission meeting. Bob, if you'll please stand where you stand for a moment. Bob has served as an investigator for the commission for 35 years, a number of them as senior investigator. He'll be ending his drop at the end of August. As I am told, we have to make him leave. This is at least once a day, somebody comes by my office and says, does Bob really have to go? By my count, I estimate he has attended around 280 commission meetings in his time, so slightly more than Mark Heron, I think. He's written or reviewed hundreds, if not more than 1,000 investigative reports. He has mentored many investigators and been a sounding board, I think at some time, for nearly every member of staff about something. And at the risk of being long-winded at the end of a meeting, Bob means a great deal to everybody on the commission staff. He's not only a top-notch investigator, but he is unfailingly kind and joyful. Everyone, and I do mean everyone, loves Bob. I think it's his superpower. It's going to be really hard to say goodbye to him at the end of August. The office will not be the same. He's always at his desk. He's always one of the last to leave after hours. And he's been our office team captain and manager when we had softball teams and volleyball teams that were very, very talented and very untalented as well. Seeing him run the bases was a sight to behold. I think there was at least one home run in there. He's quick to lend a hand professionally and personally, whether it's the additional reviews of reports, redacting disclosures, or repairing or assembling furniture when something breaks in the office, or checking under the hood of someone's car who's having car problems. Bob is the guy. It didn't matter what the issue was. We always knew we could count on Bob to come through. Throughout his career, he's ably served under 4 of the 5 executive directors, or did you get all 5? All 5 executive directors. Respondents and complainants loved him, except for maybe one that comes to mind. And I've also heard at least one member of the defense bar joke that their clients are often drawn in by how nice he is, and then they are sometimes a little too honest in their answers because Bob makes everyone feel so comfortable with the interview. Bob is the husband to Tracy, the father to Christy and Corey, and a dear, dear friend of the commission, and will always be considered family among the staff. Bob, thank you for your 35 years of hard work, dedication, professionalism, and friendship. We wish you all the best things in life. We wish you a wonderful retirement, and we hope that you'll step up and accept this plaque.
I'll miss it for certain. Thank you for the kind words of
Hey, I caught him fixing the tailgate on somebody's car.
I mean, can work as volunteer though, can
He just might. I've already been talking to him about it.
All right, that takes us to a point where Commissioner Walden can actually move for something and vote for it.
I move that we adjourn.
He moves we adjourn. And let's just kind of hang loose here real quickly to get ready for the executive session. I don't know that we have to have any setup.
We just need to get people out of the
We
room.
just need to, if people need to exit the room, and I think the mics are already set up.
5 minutes?
Yeah.
About 5 minutes.
Take a 5-minute recess.